The top law enforcement officer in the state of Texas impeached.
Republicans and Democrats in the Texas House of Representatives overwhelmingly adopting 20 articles for misconduct.
It's 10 times worse than it's been covered.
Ken Paxton maintaining his innocence, calling it all politics.
And they are showcasing their absolute contempt for the electoral process.
Now all eyes are on the Texas Senate for the first impeachment trial of a Texas Attorney General.
Everyone will do their job to the utmost in fairness.
KVUE's special coverage of the impeachment trial of Texas Attorney General Ken Paxton starts now. Good Thursday morning to you, and thank you for joining us for this KVUE Plus special coverage of the impeachment trial of suspended Texas Attorney General Ken Paxton. I'm Ashley Goudeau. I'll be joined by Tony Plohetski here shortly. We are awaiting the Senate to come to order for this, the eighth day in this trial. The prosecution rested yesterday after an eventful day, and them resting certainly led us to even more events, if you will. So let's take a moment as we look at the floor. You can see there is no one, none of the senators, Lieutenant Governor Dan Patrick. We're not even necessarily seeing all of the attorneys on the floor yet, though they are set to start back here at 9 a.m. I do believe we do see Tony Busby there. He's in the back in that light blue suit. You can see him standing and talking with someone, and that is one of the senators, Senator Lois Colhorst, coming onto the floor to place her cup on her desk. The senators who are serving as the jury typically march out together. That is the procedure, that they will come out together as a group. So it's not unusual to see some of them milling about. That's Senator Paul Betancourt also walking over to his desk. Not unusual to see them come out, sort of get their desk set, and then go back in. Senator Sparks there before they go back into the back room and then come out all together as a group. As you heard me mention yesterday, certainly eventful. The day started with what we thought was going to be a bombshell. The prosecution calling Laura Olson, who is the woman Ken Paxton had an extramarital affair with, and she walked through the doors to the Senate, was approaching the door to come into the Senate chamber. We were watching as they were opening the door. The bailiff in this trial, who is actually the sergeant of arms of the Senate, Austin Osborne, opening the door, but she never actually walked in. The defense sort of called things to a halt and pointed out that both sides had agreed that they would be given 24 hours notice before a witness is called to the stand, not only to provide that time frame and that notice to the witness, but also to the parties so that they could prepare to examine or cross-examine, in this case, the witness. And so she was not eligible to serve as a juror to be called to the stand until 3:53 p.m. because her notice had gone out at 3:53 p.m. the day before. When that happened, 3:53 rolled around, 4 o'clock rolled around. We continued to wait to see if she would be called out, and Lieutenant Governor Dan Patrick announced there was a motion, a hearing he needed to hear outside of the presence of the jury. We were not sure whether that would still happen within, the presence of the public to see, as is typically done in a criminal or a civil court. But that conversation happened behind closed doors, and when it was all said and done, he came out and announced that Laura Olson was present but unavailable and would not be taking the stand. Through our own reporting, we learned that she intended to plead the Fifth. Tony Plohetski is joining me now. Tony.
And good morning.
Good morning.
I did not sleep in, by the way.
He did not. Tony was in a meeting. We have a lot of moving parts here between, this trial happening.
I did not intentionally leave Ashley hanging out here by herself.
With the omission of Laura Olson's testimony and the prosecution resting its case without calling Nate Paul, and they were unable to call Ken Paxton, this really left the jurors with no testimony on Article 9.
No testimony on Article 9. And just going back to Laura Olson, Ashley, one of the more striking things about that is, again, this idea that she was going to plead the Fifth. Keep in mind that to plead the Fifth, you cannot do that in the protection of someone else. The Fifth Amendment is that if you believe your testimony could incriminate you in some sort of criminal proceeding. So you can't plead the Fifth in order to protect another witness or a friend or a lover or whoever. It is for your own protection. And so attorneys we were talking to last night point that out and really underscore and highlight that.
Yeah, because it just seems she's not been charged to our knowledge with any crimes. We have no indication.
Neither has anyone for that. Yeah.
In this, no indication that she's been investigated.
Is under investigation.
Nothing of that nature. You're starting to see now the jury is being called in, so the senators will come in and take their seats. And today we will hear from the defense's first witness. The defense actually called their first witness yesterday, Michael Gerhardt. He is, according to Google, we Googled someone by the name of Michael Gerhardt as a law professor at UNC, and they called him Professor Michael Gerhardt, so certainly have no reason to believe that this is not who we will hear from. But they called him yesterday, but that was at 6:30, and so then they decided, all right, we'll break for the day. We'll start with him tomorrow.
And then
Senator Hughes, I believe you're doing the prayer this morning. Prayer time. Excuse
morning,
me.
Yeah, they're getting started every morning. The Senate meets. They start with prayer, so we'll go ahead as they get started and listen in.
Let's go to the Lord in prayer. Heavenly Father, you are. When we consider who you are, the one who has always existed before time, way back into eternity, who always was and always will be. When we consider that you made everything we see, things we cannot see, us, every molecule, every particle of each of us, just because of who you are, we owe you everything. We owe you our lives. And Father, when we consider on top of that all that you've done for us, the gifts that you lavish upon us, that you heap upon us, our very lives, and especially those of us in this country, in this state, the special blessings we enjoy of liberty and opportunity and justice, unknown in the history of the world, uniquely given to us here from your hand. We know we each have a responsibility in preserving those things as stewards, each one of us, whatever our role. So Father, we thank you. Thank you for who you are, for what you've done. We confess our failure to acknowledge you as we ought, to look to you, to humble ourselves before you. And we just thank you for loving us. The ultimate expression of your love for us, that Jesus Christ, God's Son, God himself, would humble himself and come to this earth and take on human form and live that beautiful life, and then pay the penalty for all of our sins on the cross, and then raise from the dead on the third day. We thank you for him. Your word says that since you gave him for us, there's nothing you'll hold back. So Father, we ask you for wisdom that you promised to give. We ask you to be honored in these proceedings today by everyone here, whatever their role. Thank you for loving us so much. In Jesus' name we pray. Amen.
Thank you. You may be seated.
So we want to note that those audio issues you were hearing, we were hearing them too, but that's how it's being fed to us from the Senate. That is the Senate's own feed that has that echo, but we notice now Dan Patrick did not have an echo.
Did not seem
so
to
perhaps
echo.
They've gotten that worked out and we won't have that audio issue. If we do, we're going to try to find some other avenues to get clean sound for you, but just wanted to
know we've got
that.
backup after backup, so we'll explore what we need to do to make sure we can all hear well. Again, we are expected to hear, we're going to hear from the defense's first witness. Ashley?
Can we have a little quiet in the courtroom? Can I have both parties come forward?
it was an open question, I think, whether or not the defense was actually going to present witnesses. In fact, some who had been closely monitoring this trial thought that they may feel so strongly that the prosecution had not met their burden of proof or come close to meeting their burden of proof, that they were going to be willing to call it game over and move straight toward any sort of rebuttal evidence or even closing arguments. But then, obviously, Tony Busby announced yesterday their first witness. And
so this will be certainly interesting to hear, considering our previous witnesses have been people directly tied to these articles, the whistleblowers themselves, people who were members of Ken Paxton's staff, though not whistleblowers, but had direct knowledge of what was happening. And now we're going to have a law professor come in. And so...
Justin Gordon.
And that is a change. And so yesterday, the witness that they called was Michael Gerhardt, but this morning they've called Justin Olson. Justin Gordon, excuse me, Justin Gordon.
Who is?
House, you have 2 hours, 34 minutes and 49 seconds remaining. A respondent, 8 hours, 38 minutes and no seconds remaining.
So, important to note there, the timing and all of this, the prosecution will have about 2 hours to cross-examine any of the defense's witnesses. The defense has 8 hours remaining in this trial. And so, or 2.5 hours, excuse me, that the prosecution has compared to the 8 hours.
Yeah. Ashley, Justin Gordon is an assistant Texas Attorney General who oversees the Open Records Division. He is the Open Records Division Chief, according to his LinkedIn page. So clearly we expect testimony from him concerning possibly the open records request. 2 open records requests have been the subject of this proceeding. One dealing with the foreclosures allegedly to benefit Nate Paul, an opinion allegedly to benefit Nate Paul, and another one for law enforcement records.
And he's already taken his oath, and so we're going to get straight to his testimony. Let's listen in.
Good morning, Mr. Gordon. How are you today? Could you please turn on your microphone and go ahead and adjust it pretty close? The acoustics in here can be a little difficult.
Is that okay?
Yes, that's much better. Could you please state your name for the court?
My name is Justin Gordon.
And where are you currently employed?
I'm employed in the Open Records Division of the Texas Attorney General's office.
And what is your position there?
I'm the Open Records Division Chief.
How long have you been the chief of the Open Records Division?
I began in 2015 at the beginning of General Paxton's term.
Excuse me, I think you're going to have to speak louder and a little closer, okay?
I began in 2015, in January of 2015.
What does the Open Records Division do?
Our division handles a number of responsibilities regarding the Texas Public Information Act. That includes enforcement and review of public information decision requests. We also provide training for governmental bodies on the Public Information Act.
Okay, I'm going to ask you just to slow down a little bit while you're talking, okay, to help the court reporter out. Can you tell us how many public information ruling requests your division handles a year?
Last year we did over 40,000. In the previous fiscal year we did just under 40,000.
And does your division maintain a record for each ruling request?
Yes, we maintain both an internal record of our ruling requests. We also post all of our letter rulings on our website after they are issued.
Do you recall a request for ruling from the Texas State Securities Board in the fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of that ruling request?
I do not believe any records were released in response to that ruling request.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was.
How frequently does the Open Records Division receive requests for reconsideration or complaints about a ruling?
That's very common. I don't have an exact number to provide you, but that's something that we see certainly on a monthly basis, if not weekly.
also involved in deciding a request for ruling from DPS, the Department of Public Safety, in the spring of 2020, which we're going to call the big request for ease of reference. Do you recall that one?
Yes, I do.
Was that also related to Nate Paul, if you recall?
It was.
At some point, as one of your duties, as part of your employment, did you make a summary of that file?
I did.
Your Honor, if I may approach the witness.
Yes, you may.
I'm going to approach with what is marked as AG.
Hold on one second. Yes, Senator Whitmire? Okay. Allison, you're going to have to speak louder as well.
Even louder. Okay.
That'll do it. That'll do it.
I'm going to approach with what has been marked as AG 205, and it has been pre-admitted.
Members, do you need for us to review with the court reporter what has already been said? You're okay? Everyone's okay? You do? Okay. Okay, so let's go back to where you began the question on DPS, Senator West. Securities. Okay, let's start over.
No problem. Do you recall receiving a request for ruling from the Texas State Securities Board in fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of ORD's ruling?
No, I do not believe any records were released in that ruling.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was a request for reconsideration.
How frequently does ORD receive requests for reconsideration or complaints about a ruling?
That's very frequent. I don't have an exact number to provide to you, but it's something that we see, if not on a weekly basis, then certainly monthly, several times a month we receive reconsiderations.
Do you also recall being involved with a request from DPS in the spring of 2020 related to Nate Paul?
Yes.
Now, we've been calling that the big request to help distinguish them. Will you understand what I'm saying if I call it the big request?
Yes.
Thank you. And at one point, as part of your employment, did you create a summary of this file?
Yes.
Your Honor, I'm going to approach the witness with what has already been admitted as AG 205. Mr. Gordon, do you recognize this document?
I do.
Is it a fair and accurate depiction of the summary that you created for this file?
Yes, it is the summary I provided for the file.
Well, let's talk about it. Let's walk through it together, okay?
Okay.
First, how would you describe this particular request, the big request?
It started off as what I would have characterized as a relatively routine request from the Department of Public Safety. Department of Public Safety routinely briefs our office on law enforcement matters. They, again, very commonly submit rulings to our office. However, as the ruling was being reviewed, it took a turn procedurally, and then there was a number of procedural irregularities that occurred with the file that made it unique.
And Eric, if you could please pull up AG Exhibit 205 and highlight the first paragraph, please. And Mr. Gordon, I think it's consistent with what you just said that there were procedural issues that made this file unique. Is that correct?
That's correct.
Okay, and when was the request received by your office?
On March 13th.
Okay, and at this point, this is when you're talking about it was very routine?
Correct.
Do you recall what exception DPS was asserting?
They sought to withhold the information under the law enforcement exception. That's Government Code Section 552.108.
Is that, there are generally two types of exceptions under the PIA, is that right?
That's correct. There are two, we characterize them as two separate types of exceptions. There's an exception for confidentiality provisions that we would also call mandatory exceptions, and there's a type of exception that is just a normal exception to disclosure that we would call a permissive exception to disclosure.
And which type is the law enforcement exception?
Section 552.108 is a permissive exception. The governmental body has the option to raise it or not to raise it.
What happens if they do not raise it?
Nothing happens if they do not raise it. We won't address it if they do not raise it.
So if they don't raise it and you don't address it, what's the end result as it relates to the request? Are those records released or are they withheld under the law enforcement exception?
Oh, they would be released. They would not be withheld under the law enforcement exception.
So let's talk about some of the procedural irregularities in this file. I'm now in the second paragraph, Eric, if you could blow that up for the senators. Where did this file first start to take a turn towards the unique?
Where you have it highlighted, I described that.
Excuse me one second. I'm very sorry, and I'm very understanding with 8 grandchildren and a lot of little ones, but we really can't have a distraction. I'm sorry, might have to step out. I really apologize, but I don't want to distract the jurors. Very sorry for that.
May we continue? Thank you. I believe you were about to point out to us where the procedural issues started to rise in this file.
Sure. So we have a statutory 45-day deadline by which we have to issue all of our rulings. That's from the government code. And as we were approaching that deadline, the DPS submitted a follow-up correspondence to our office explaining that the requested information may implicate the interests of the FBI. And at that time, they also submitted additional records. So in the initial submission, they only submitted a representative sample, which they are permitted to do. In fact, the PIA requires them to do that if the records are voluminous, and they had done that in the initial submission. However, when they submitted the subsequent submission, they submitted additional documents, not the same representative sample that they had submitted earlier. And the new documents were substantially different than the documents that had been originally submitted and were of a different character. So they
and I'm going to stop you. I think that's a great spot. And just to summarize, so essentially the original representative sample that DPS sent in did not match with the sample that they later sent to your office in May of 2020. Is that right?
That's correct.
And they sent that second sample at the time that they were notifying the FBI that they might have an interest in the file, in the information being sought by the request?
That's correct.
Is that considered a procedural violation under the Public Information Act?
Yes, governmental bodies are required to submit all of the records that they want a ruling on or a proper representative sample by the 15th business day after receiving the request, which had been substantially before this time period.
So this sample was also late, is that correct?
That's right. That's correct.
What is the consequence for a procedural violation of this nature?
Under the Public Information Act, failure to comply with the procedural requirements in requesting decision from our office results in a presumption that the information is released unless the exception that they're raising constitutes a compelling exception. And our office has concluded that Section 552.108 does not constitute a compelling reason. That's a fancy way of saying that they waive that exception, and they would waive it for the information that they had the procedural violation on.
And that would be all of the information that they provided as the second sample in May of 2020?
Correct. Anything in that representative sample, the second set of documents that was not in the first set.
And is it your understanding that that second set of documents had also been provided to the FBI?
Oh, I'm not sure if they provided that second set of documents to the FBI. I don't remember that.
So this is late, was the notice to the FBI also late?
Yes. Governmental bodies there are procedural requirements and there are also due process requirements in the Public Information Act, and because of those deadlines, there are certain notice requirements. So the only notice requirement in the Act that applies to third parties is in section 552.305. That section requires governmental bodies to notify third parties if their privacy or proprietary interests are at issue, and that notice is supposed to come within 10 days of receiving the request. Otherwise, there's also the due process element of that notice needs to be made in time for those comments to be received by our office before, in time for us to be aware of them, and also in time for the requester to receive notice.
And in this instance, was the notice given close in time to your statutory deadline to issue a ruling?
Yes, we received it just a couple of weeks before our 10-day deadline, or our 45-day deadline.
The second sample of the second set of documents that you were provided by DPS, how were those provided to you? Hard copies on a CD, do you recall?
I don't recall if they were a CD or if they were a hard copy.
Okay, so you sent the notice went out to the FBI and you received a copy of it. What happens next?
So at that point, we were kind of up against it with respect to the timelines. You've got the highlights here with respect to the to kind of what was going on in this file. We had also been notified by the requester in this file that he had filed a lawsuit against DPS in this case, which added a whole nother layer of complexity to it. Because the late notice, because the notice was received so close up against our 45-day deadline, we didn't feel like the third party who was notified, FBI, would have had time to submit comments to our office in time, and so while we were waiting for those comments so that we could receive them and review them from the FBI, we took a 10-day extension on it, and again gave ourselves a 10-day extension, which is permitted under the PIA.
All right, I'm going to ask you just to slow down a little bit, okay? You're doing great. So you extend it for 10 more days. Does the FBI eventually provide your office with comments?
Yes.
And do you know if the FBI also provided the requester with a copy of those comments?
At the time, when we identified the documents, we actually only found the comments because the requester let us know that he had received comments, and so then we went and tracked them down. This is at the beginning of COVID, so our mail intake was kind of thrown off. So when the requester notified that we had received comments, we went and tracked those down. To add another procedural complication to it, at that time, the requester notified us that his copy of the comments had been completely redacted. Our copy did not have any redactions on it. It just had a reference that at the end that the version that had been provided to the requester was redacted.
In your honor, if I may approach with what's been marked as House Managers 46 but has not been admitted into evidence yet.
You may approach the witness.
Mr. Gordon, do you recognize the document that I placed in front of you?
I do.
What is it?
This appears to be a copy of our internal ruling file pertaining to the DPS file that we've been discussing.
And does it appear to be a complete and accurate copy of the file?
I'm sorry, I'm just double checking.
Take your time.
Yes, it does.
I appreciate your thoroughness. At this time, we'd move to admit House Managers 46.
Any objection?
Mr. President, no objection to the admission. However, in this document, it contains a copy of the unredacted FBI brief, which not only contains personal identifying information, but a number of sensitive information of the types of operations plans and other sensitive law enforcement information, which Nate Paul had been trying to get for a while. If it comes in, we just ask that it be redacted because that information has not been publicly made available.
And Your Honor, we'll get to that on the next request, but I will represent to this court that that is not the case. As has been discussed by other witnesses, this brief was in fact released publicly.
Okay, so they did not object, and I'll let her go along with her line of questioning, and we'll get back to that issue, but thank you for bringing it up. Go ahead.
Thank you. Eric, if you could pull up towards the back of that Exhibit 46, the Bates number at the bottom is 8803.
Mr. President, I do have to, I'm sorry, before this is shown to the jury, there is personal identifying information
and
that
sir,
has not, may I finish?
Stop not talking over each other.
That has not been released publicly. It may have been released to Nate Paul at General Paxton's direction. However, it has not been made public to the world at large. There's very sensitive law enforcement operation plans, details about search warrants, how investigations are done, and also specific names of individuals that are identified and involved.
Come on up to the bench. Please come up to the bench.
Yes, sir.
And so let's talk a little bit about the articles of impeachment related to the testimony that Justin Gordon is giving us now. So it's
relating to open records. He is the chief of the Open Records Division for the Attorney General's office.
And he oversaw sort of what was happening at the time with these particular records that were being requested. Article 3 accuses Paxton of misusing his official power to administer the public information law, and that he directed his employees to refuse to give a decision for a request for DPS records. So typically, if someone wants to get some records or some information from really any law enforcement agency, and they have to, the agency denies, and then they have to request an opinion, typically the Attorney General's office either tells you, yes, you can have them, or no, you cannot. But that's not what happened in this case.
That's not what happened in this case. There were some procedural issues, according to Justin Gordon. And he says DPS missed key deadlines to argue that the information should not be released. And under the law, if a law enforcement agency does not argue on its own behalf, there is a presumption that the records can then be made public. So Ashley, where I think we are seeing Mr. Gordon's testimony go is that Ken Paxton was trying to do the just and righteous thing, which is DPS had missed their deadline, the records were public.
Right, and so that brings us to Article 4, which is disregard for official duty. It alleges that Ken Paxton misused his power to administer, again, the public information law, and then improperly obtained access to what at the time was non-public information and shared it with Nate Paul for Nate Paul's benefit. And so some of that information is, we have heard, and certainly this is what they're talking about now, Nate Paul wanted information on the agents who had raided his properties.
And not only the agents, but also these types of records that he was seeking include key investigative information, what they were going after, the types of records or documents or materials that they were going after. Yes, the participating agents and personal information about them is often contained. Also, often contained in documents like this are law enforcement strategy and operational information. And that's why law enforcement is often so loath for information like that to be in the public. And Ashley, that's exactly what they are at the bench discussing right now.
Right, because it does include, the prosecution says, these documents include the names of these law enforcement officers and that those names have not been made public as of yet, but the defense is arguing, well, no, it became public when they missed the deadline, and then that is why it was, shared with Nate Paul, and therefore it is public.
And to that end, we know that Nate Paul ultimately did receive information, obtain information from those documents because subpoenas were served pursuant to some of the names that flowed from that document to his attorney, Michael Wynn.
And one of the things, and this all sort of reverts back to what Nate Paul's claim is, when a search warrant is executed on your home, your business, your whatever it may be,
your garage, your shed, your
car, you do not get to know what the police are looking for. That is not information that is shared with you, the person whom the warrant is being served on. They tell you they have a warrant. It outlines where they can go, and they go, and that's for the integrity of the investigation. Surely, if you knew what they were looking for and you had done wrong, you would dispose of that.
Now, sorry if you'll go with me into the weeds here. Often in state district court, after that, you can very often get a copy of a search warrant. But in federal court, but in federal court, those warrants are often sealed indefinitely for a long period of time, and even after a charge may be brought against a person. So I don't know why I felt the need to say that, but just a little bit of
to point out, because you've heard the prosecutors say he gave these sealed documents, these federally sealed documents, because the FBI was working with DPS,
and the State Securities Board.
Right, to execute these warrants. And particularly what Nate Paul believes is that when they raided his properties, the time has been thrown out at 9 a.m. in the morning. After 2 hours, they were initially looking for drugs and guns. And after 2 hours of not finding that, in his mind, they altered the search warrants there sort of on the spot, and that there was this, conspiracy with not only the agents that were there, but also
the magistrate judge who signed it, maybe the magistrate judge's staff.
The U.S. Attorney's
office,
who all, and this clerk, and going even further into, the conspiracy that he had about what was happening against him, is that this clerk who handled these documents, who had died under suspicious causes, and there was foul play suspected in her death.
And that was just kind of tossed out. I think we were both raising an eyebrow about that. But in terms of that information really being developed,
but the reason
it never was.
It was a bit, because Brendan Kammick went and questioned the widower. And when he questioned the widower, that is what prompted the FBI. He later
The point I'm trying to make is that they did not get into her cause of death and what actually happened to her.
No, they didn't tell us what happened to her. But certainly we know that Brendan Kammick who was hired, he says, by the Attorney General's office to serve as a special prosecutor. Him going to the widower's house is what prompted the U.S. Marshals to then start looking into him and go to his office.
Correct. Then he called Ken Paxton. This was all testimony 2 days ago.
Take what you will from that information, whether it is a conspiracy or not. But that's the information basically about the warrant and whether the warrant had been changed that Nate Paul was trying to get. And again, there have been arguments from, certainly the top aides in Paxton's office but this is not the venue to pursue that type of investigation.
That there were a couple of options available, including the Federal Government Inspector General's office, the courtroom, that there were other avenues to pursue. And Ashley, they haven't gotten to it yet, but given Mr. Gordon's position as the chief of the Open Records Division, and we can also anticipate that he may provide testimony related to a second article dealing with open records.
Well, are you talking about the opinion?
Yes.
Okay.
I'm talking about
we do have two related.
That's right.
We have two articles related directly to the open records request. That's articles 3 and 4, and then Article 2 deals with legal opinions and the request for a opinion from the Attorney General's office, which we've heard a lot of testimony about, regarding whether or not foreclosure sales could be happening during the COVID pandemic pursuant to Governor Greg Abbott's executive order. It was order number 28 that, had restrictions on and bans on gatherings during the COVID pandemic.
And the allegation is that Paxton ordered his staff to, well, you can see it there on your screen. Essentially, Paxton ordered his staff to craft an opinion to stop a foreclosure sale in a way that would benefit Nate Paul. So two important open records decisions that are the subject of two of the impeachment articles against Ken Paxton. So presumably Mr. Gordon is going to be in a position to offer testimony concerning both of those. And Ashley, it's important to note that with regard to the foreclosure sale opinion, Tony Busby and Ken Paxton's legal team have presented evidence that ultimately the opinion that did come out of Ken Paxton's office followed closely. It tracked a federal order that came down days later from then President Trump.
Yeah, a little while later, but at the time it didn't. And we
That's
heard
right.
testimony that order from Paxton actually halted the foreclosure sales. We heard from the president of the credit union that was preparing to put 3 of Nate Paul's properties into foreclosure because he owed them $11.5 million and had not been paying on those loans. And he said he received that order on a Sunday, which was most unusual. We've heard this referred to as the midnight opinion because it happened so quickly over the weekend. The staff actually wrote the opinion opposite of what Ken Paxton later told them he wanted, and they initially wrote it to say that those sales could carry on, and we heard them cite yesterday. We heard from one of the whistleblowers who said Paxton had just himself had an outdoor fundraiser, and so surely they thought that outdoor foreclosure sales could still happen.
Appropriate.
Yeah, given this time frame, but that when Paxton saw what they wrote, he told them, no, reverse it. We want to say that they are not allowed, and that stopped that foreclosure sale.
And Kendall Garrison, who is the president and chief executive officer of Amplify Credit Union, providing testimony that decision did, in fact, injure his organization, his financial institution, and that they essentially lost money and were able to suitably foreclose on Nate Paul's property and obtain some of their money.
Well, that they sold them, that they sold the loans.
Right.
Out, but that the foreclosure sale did stop because of the opinion.
Exactly.
So certainly interesting testimony we received there. We see the witness has taken the stand yet again, but we see after those arguments have been made from the attorneys, Lieutenant Governor Dan Patrick is consulting with his legal team. The rules allowed him as the presiding officer to have legal counsel in this matter on how to rule. And, we've seen him certainly lean on their expertise, and also we've seen him throughout this trial make decisions on his own.
Well, and attorneys who are closely watching this trial, I interviewed a group of them last night. We're talking about, just how inconsistent Dan Patrick's decisions seem to be with regard to granting objections or overruling objections. But because of the nature of this trial, there is no one to appeal to. In other words, in a regular civil or criminal trial, you can appeal to a higher court. That is certainly not the case. Whatever the senators vote on in coming days is what lands, is what sticks.
One example of that just stands out in my mind was during prosecutor Aaron Epley was up, and Tony Busby objected, and the objection was overruled twice. But then when she continued, when she was continuing to try, eventually Dan Patrick sustained the objection that he had just overruled. But it looks like they're starting back up, so let's go ahead and listen in.
Can't hear her.
Members, take your seats. So we're going to proceed slowly carefully. You may proceed.
Thank you. Mr. Gordon, as a preliminary matter, if a document is released after a ruling request or a ruling decision, would that be released to a subsequent requester for that same information?
Objection calls for speculation.
Overruled.
Yes, there's a specific section that directly addresses that. Section 552.007 of the Government Code prohibits the governmental bodies from selectively releasing information and provides that if information has been released to one requester, then it would be released to a subsequent requester unless there's a special right of access that applied to the initial requester.
Okay.
Sorry.
All right. Mr. Gordon, repeat your answer. Slow down.
Yes, sir. Yes, there is a specific section of the Public Information Act that addresses that. It is section 552.007. It provides that if information is released to one requester, then it would be released to a subsequent requester. It prohibits the selective release of information to one requester and not to another. So if information has been released by a governmental body, then it would be released to subsequent requesters unless there is a special right of access that only applied to the initial requester. For example, if I ask for my driver's license number and receive it, you wouldn't release my driver's license number to the next person because I have a right of access to that.
Thank you for that explanation. Eric, could you please pull up within House Managers 46 at Bates 8803, which is page 77 within that PDF. Mr. Gordon, can you see that on your screen?
Yes, I can.
Does this appear to be a fair and accurate picture of the redacted brief the FBI provided to Mr. Larson?
That's correct.
And Eric, if you could scroll to the next page, so to 78, go down. Is this showing an entirely redacted page?
Yes.
And does that continue through the majority of this brief?
Yes.
Is this unusual?
Yes.
Can you explain why?
Under the Government Code, if a third party submits comments to our office objecting to the release of information, they're required to notify the requester and provide the requester with a copy of those comments. They are permitted to redact the comments, but only to the extent that it reveals the information that is requested. In this case, they've redacted the entirety of the brief, including all of the substantive arguments.
And why does that matter?
That matters because the requester was not put on notice about what arguments the governmental body was making and would have been unable to respond to them to our office in order to refute any statements that were made or directly address the statements that were provided by the briefing third party.
Is this another procedural violation of the PIA?
Yes.
So far we've talked about at least 3 procedural violations or irregularities with this file.
Objection,
Yes.
leading.
Restate your question. Sustain.
Can you estimate for us how many procedural irregularities we have discussed related to this file so far?
There was the failure to submit the representative sample, or they submitted the documents late. Mm-hmm. The representative sample that they submitted the second time was not indicated that the first representative sample was not actually representative. They did not notify the third party in a timely fashion, and then when the third party briefed us, they substantially redacted their briefing to us. Or I'm sorry, they substantially redacted the copy of the briefing that was provided to the requester.
Are you able to tell us how frequently you work on a file that has 4 different procedural irregularities?
We see a lot of procedural irregularities. These are pretty unique, though, in the way that they came in. Ordinarily, what we see are missed deadlines. So it would be pretty rare that we see 4 completely different procedural violations like this.
And again, what can be the consequence of a procedural irregularity of the nature you've been discussing?
If a governmental body fails to comply with the procedural requirements of the Act, then they would waive their discretionary exceptions.
Meaning that any documents that fell within a discretionary exception would be released?
Objection leading.
Sustain, rephrase your question.
So what's the consequence of that, of the permissive exceptions being waived?
If a permissive exception is waived, then we would not apply it or review it in the context of those documents. And if that's the only exception that's addressed, then those documents would be released.
And in this particular file, the DPS file in front of you, was the only exception raised the law enforcement exception?
That's correct.
And it is a permissive exception?
That's correct. They did not raise any confidentiality provisions. They only raised the law enforcement exception.
Do you recall meeting with the Attorney General about this file?
Yes.
And I don't want you to go into what anyone said at that meeting, okay? But could you please tell us what topics were discussed?
We discussed this topic, this DPS file.
Did you discuss options for how to proceed?
Yes.
And what were those options?
The primary options were to release the information, to conclude that there had been a procedural violation and a failure to establish that the information was accepted from disclosure. And then the second exception, which was the primary option, was the closed letter that we ended up issuing.
Did you agree with issuing the closed letter?
Yes.
Why?
It was correct. The procedural background of the request put the requester at a significant disadvantage, and allowing the procedural actions that were taken would have really been a detriment to that requester. There was already a pending lawsuit, and courts will give our letter rulings great weight, and rubber stamping the actions in this procedural context would have, or could have, I don't know what the court would have done with our ruling, but it could have tilted the scale in favor of a governmental body who had failed to comply with the procedural requirements.
And I want to make sure I understood your testimony a moment ago. You considered releasing all of the information. What do you call that within ORD?
Pouring out.
And would that have been supportable under the law, in your opinion?
It would have been pushing it. I agree with the closed letter. I feel like releasing it all would have been pushing it.
To your knowledge, had ORD issued closed letters of this nature in the past?
Yes.
Eric, I'm going to ask you to pull up the closed letter, which is within House Managers 46 at page 2, and please take it off the screen before finding the new page and placing it there.
Counsel, what was the page number that you directed him to, please?
It's page 2 of the PDF, which is in front of you.
That OAG 8728?
I don't have it in front of me, but it's the closed letter. Mr. Gordon, does this appear to be a complete and accurate copy of the closed letter?
Yes, it does.
And in that letter, you reference a prior ORD decision, right?
That's correct.
Why? Why did you reference that prior ORD decision?
Well, there were a lot of reasons. The primary reason is that what this open records decision specifies is that if a lawsuit is filed after a ruling request is made, I'm sorry, let me take it back and maybe simplify it. Under the Public Information Act, a requester can sue a governmental body if they believe they're improperly withholding documents. What this open records decision provides is that if a requester files a lawsuit after a governmental body has issued or has requested a decision from our office, then our office should still go on and issue a ruling. Prior to this decision, we routinely closed files and did not issue determinations where the issue that come before us in the decision was in court. So we would demur and close that letter and let the court decide.
And in your opinion, how did this DPS file differ from the closed letter that you issued in this case? How did that differ or was distinguished from that ORD decision?
It was all of the procedural irregularities, especially the redacted FBI brief. That was the primary issue that prevented us from ruling in accordance with due process. It was the heavily redacted FBI brief.
And why did that cause you so much heartburn?
Again, our rulings are given weight or great weight, quote unquote, by the courts. And in the face of those procedural irregularities, giving a rubber stamp of approval to them could have tilted the scales in that court, even despite the procedures being handled incorrectly.
Could it also set bad precedent?
Objection leading.
I'm asking his opinion, Your Honor. It's a yes or no. He can say what he'd like.
Overruled.
I'm sorry, I didn't understand. I didn't hear the question.
Sure. Could it also set bad precedent in PIA requests coming into your office?
Objection, Your Honor. The relevance of this personal witness's opinion is not relevant to any issue in this proceeding. And what he considers a good or bad precedent is purely subjective and not at issue in this case.
Your
Overruled.
Honor, thank you. You can answer the question.
I wouldn't characterize it as a precedent. So many of our rulings are fact specific. What I do think it could have resulted in, because DPS and FBI routinely brief our office, it could have again been seen as condoning that type of heavy redaction, which then could have led to that type of action being taken in future requests and for future requesters. So I wouldn't have characterized it as a precedent, but it could have indicated that we thought that was okay, and then they would, because they do it routinely, they request decisions from us routinely, they could have seen that as oh well, now we've got the stamp of approval to do this, and now we'll keep doing it.
And now, while all of this is going on, were you made aware of a request from Mr. Larson for a copy of the FBI brief?
Yes.
How were you made aware of that?
That came in as a Public Information Act request. The Public Information Act request was forwarded to my division for handling. And when I say handling, I mean we collected the documents. So we collected the unredacted brief in processing that Public Information Act request, and we provided it to our Public Information Office.
As to the DPS ruling itself, did that closed letter result in the release of any documents?
It did not.
Okay, so this request from Mr. Larson comes in for a copy of the brief. Do you know what happened after that was received?
I know what happened after the fact. Because it involved open records decision documents, our division does not rule on decision requests for our own documents, so it was handled by another division. But through the process of this whole circumstance, I did become aware of what issued or what happened with that public information request.
And your division maintains those files even if it doesn't necessarily make the decision on the request, correct?
That's correct. Because the FBI submitted the brief to our office, we were the ones who maintained that as part of our work file.
Have you reviewed the ORD file for the FBI brief request before?
So just to clarify, our office, or my division, does not have a file on that public information request. We have the file that's here before me as this PDF, and yes, I have reviewed that, but I have not seen the opinions file or Public Information Office file involving that, that ruling request for that brief.
Now, in the file in front of you, there is a copy of the unredacted FBI brief, correct?
That's correct.
Would you take a look at it, please?
Okay, I'm looking at page...
And what I want you to look for, you know, you're the chief of ORD. I want you to set aside law enforcement exception for a moment. I want you to look at that brief and let me know if you think there are any mandatory exceptions to public disclosure that are flagged within that brief.
Not to nitpick, but there is Mr. Larson's email address is at the end of the brief, but he was the requester. So no, but other than that, I don't see any confidential information on the face of the document.
Thank you. And just one more thing on, oh, forgive me. Your Honor, if I may approach with what's been marked as AG 34.
You may.
Mr. Gordon, do you recognize the document I placed in front of you?
I do.
And what is it?
This would appear to be the internal file for the opinions ruling request that we've been discussing that was Mr. Larson's request for the unredacted FBI brief.
Does OAG receive requests for copies of PIA briefing on other occasions?
Yes.
Does that occur can you tell us with any sort of frequency how often you receive that type of request for briefing?
If I had to guess, I'd say it would be once a month, probably less than once a month it's not very common. It's not a weekly occurrence.
And were you familiar with Joe Larson?
Yes.
How?
I've worked with Joe Larson for a long time. He is a well-known open government lawyer. He's also involved with the Freedom of Information Foundation, which our office has partnered with in the past to perform trainings. He's routinely sought after to provide input on Public Information Act requests. I've also observed a number of cases that he's handled because he ends up often handling important Public Information Act cases. So I've known Mr. Larson for a long time.
Was, based on your knowledge of Mr. Larson and working with him, was it surprising or unusual for him to submit a request for a copy of that redacted brief?
No, I wasn't surprised at all that Mr. Larson would ask for that.
And you started to walk us through what OAG does when it receives a request for documents that OAG itself holds. I just want to make sure that's clear for the jurors, okay? So let's walk through it. So what's the first step OAG would do when it receives a request for records that it itself holds?
That would be received and handled by the Attorney General's Public Information Office.
Objection, Your Honor. I apologize to the witness, but at this point, it's clear from the witness's own testimony that once this request that's about to be discussed was made, it went to a different division, not his, that he does not oversee, and he's previously testified that he was not involved. So any information that he has about specifically how it was handled or by whom would be hearsay or speculation.
Your Honor, right now I'm asking him to walk through the general process of how this is handled, which is something that as the chief of ORD, he is intimately familiar with.
The witness can answer. Overruled.
When a request comes into our Public Information Office, the Public Information Officer will identify the divisions that they believe maintain documents, and they will notify those divisions. Those divisions then collect the information. Generally, we collect the information unless there's some issue with the request, like we don't understand it or it would require a cost estimate. Those divisions, my division in that case, will respond back that we maintain documents, and then we'll follow that up by providing those documents. If a decision is required, then the Public Information Officer will prepare that decision, and they will send it to our division. As soon as we see that we've received a request from the Attorney General's office, it gets segregated out, and at this time, it would have been forwarded to the Opinions Division.
So ORD is not deciding decisions on documents held by ORD, is that right?
That's correct.
Action leading.
Sustained. You can re-ask the question.
I think the point's been made, Your Honor. I'm gonna move to admit AG 34. It is an internal business record of OAG. It was actually given to us pursuant to a business affidavit that has been on record for more than 14 days.
And Your
Any
Honor,
objection?
as we discussed at the bench, the issue is not the business records affidavit. It is protecting the sensitive information of law enforcement, how they conduct their investigations, and specifically the individuals involved. An exact identical copy of the same brief we just talked to you about at the bench is also contained in this document. And so I have no objections as long as she's willing to protect law enforcement and the integrity of their investigations and redact that sensitive information. With those redactions, no objection.
And Your Honor, the chief of ORD has now looked at this brief and told you that there were no mandatory exceptions and no confidential information within that brief. Mm-hmm. He's also testified that once a brief is given to once documents are given to one requester, they are given to any subsequent requester. They are considered public. And so I do believe that he is more than very highly qualified to speak to this file, and that there are no confidentiality concerns raised within it based on this witness's testimony.
Brief response, Your Honor.
Yes.
Everything my colleague said misses the point. All I'm trying to do is make sure that the sensitive law enforcement information, which is in front of you, the identities of the individuals involved in the investigation, how they conducted the investigation, their sensitive operations plans, their sealed search warrant affidavits and the details contained within, how they communicate with each other, who was on those communications, and when they were sent, all of that information I just would ask would be redacted. Otherwise,
and Your Honor, very quickly.
Stop. Don't talk over each other. Court reporters have a tough job, as it is. Come up for a moment again.
And you've been listening to testimony this morning from the defense's first witness. He is an official who works in the Open Records Division of the Attorney General's office.
Yes, Justin Gordon, he's actually the chief of the Open Records Division and is certainly providing some interesting testimony that speaks directly to some of the articles of impeachment. There are 2 articles of impeachment that allege Ken Paxton misused the open records law in order to, 1, have his staff not give an opinion in a request, and 2, to then give information to Nate Paul, the House managers would say for Nate Paul's benefit, about the search warrant that was conducted on his properties.
And again, this all speaks to whether or not the question and the allegation that Ken Paxton abused his office to essentially get information to Nate Paul about this investigation, a federal investigation, which, by the way, very much ultimately did result in federal charges against Nate Paul that happened over the summer. The issue right now, though, is the degree to which a brief compiled by law enforcement is going to be submitted into evidence. You can hear the House prosecutor vigorously arguing or vigorously attempting to make sure that there is not sensitive law enforcement information that is put into the public domain, but at the same time, the attorney for Ken Paxton's legal team is arguing that this is public information and therefore it is public.
Yeah, and interesting to hear him say, the chief of the Open Records request, that, well, once one person asks for it and it is granted to them, it can then be given to anyone else who asks for it. It is in the public domain. You know, you have to wonder, while yes, all of the documents that will be submitted in court are public, whom they want to keep this from. I don't think the general public is going to go and
racing
look at
down
to get these documents, or even that they would want to request necessarily to see who served this search warrant in Nate Paul's properties. But at the same time,
well,
Tony,
Nate Paul and his defense, they know at this point. It's out there.
But also, and what we're hearing the prosecution say, it also talks about their tactics and their strategy and how they do things. And so I think that certainly is interesting. But even as we talk about that, the fact of the matter is, that information had already been given.
Right, the horse has left the proverbial stable at this point. But you know, for whatever reason, and I think she feels as though I don't know what she feels. Her argument suggests that the reason the House prosecutor is arguing so strenuously is to protect the potentially confidential information about this law enforcement activity and this law enforcement operation that targeted Nate Paul.
And so it will certainly, and it's interesting because they've already argued this once this morning about whether or not these documents should be submitted to the court. And basically they've argued once and kind of decided they weren't going to move forward with that, but then it's coming up. It's coming up because the very document that they argued about is included in another set of documents that the defense wants to submit. And so here we are again. So essentially, if you didn't get the info in the first time, you're going to try to get it in the second time. So will be interesting. I just want to note also, because as we are, entering the late morning hours of today, to talk about the time, Lieutenant Governor Dan Patrick previously said that he expected both sides would be out of time today. Mm-hmm. By the end of today, that they would have both used their 24 hours that they are allotted to present their case and cross-examine their witnesses.
And we actually have a graphic that shows the time that has been set out during the course of this trial. There it is.
Yeah, so each side. And interestingly, we want to note that the prosecution did not use all of its 60 minutes in opening. They used about 20 minutes of that and said they wanted to save their time for the witnesses. The prosecution rested yesterday with about 2.5 hours left. And then
And just a quick pause there, Ashley. I mean, there was some discussion about that. I mean, Rusty Hardin.
well, he said he made a mistake.
He said he made a mistake.
So basically, he had finished questioning Blake Brickman, who is one of the whistleblowers, who was the Deputy AG for Policy and Strategy Initiatives in Paxton's office. And he was a very straightforward.
Yeah, one of the plaintiffs in the lawsuit.
He's one of the plaintiffs in the lawsuit. And interestingly, we mentioned that he was a plaintiff in the lawsuit, but he wanted more than anything, more than any amount of money, an apology.
And I'm sorry from Ken Paxton.
For calling them rogue employees.
Which he got
right.
as part of the tentative settlement agreement. Ken Paxton did apologize and, in fact, removed a statement from the Office of Attorney General website apologizing for that called them rogue employees. Removed that statement.
And so when we came back, let me say this, we came back and we heard testimony from him, and the prosecution wrapped its case. And before that, there was a hearing behind closed doors to talk about whether or not Laura Olson would be testifying.
And that was, I mean, clearly, let's be honest, one of the most dramatic moments of the whole trial.
Absolutely.
I mean, certainly of yesterday, but her testimony is certainly something that clearly House impeachment prosecutors and managers had wanted. And again, a lot of discussion about why they did not simply call her to the stand yesterday and have her plead the fifth on the stand. There are a couple of schools of thought about that, including that it would have just eaten into their time had they done that, and that there was truly ultimately nothing to gain. We know, according to Lieutenant Governor Dan Patrick, that both sides struck an agreement phrasing that the Lieutenant Governor would announce to the crowd. So that happened, and then Laura Olson left the Capitol.
And it's interesting when we say, you know, they might not have gotten anything from her, but she certainly is, from the prosecution standpoint, the only person that could have provided some insight to Article 9. Article 9 alleges that Nate Paul hired Laura Olson to come work for, you know, his company in Austin. She was living in San Antonio at the time that she was going to come live in Austin, and that was sort of payment, if you will, for lack of a better word, to Ken Paxton for helping him with his case and helping to investigate his case, that, you know, he then in exchange hired Olson. And we've not heard any testimony that speaks to this article. Frankly, unless something amazing is going to happen in the rebuttal evidence, we've not seen anything related to that article.
Well, and I was going to say, I mean, you can pretty much assure yourself that Team Paxton and Tony Busby and Dan Cogdell are not going to go there. They don't want to go there, clearly. Dan Patrick is saying something.
So be seated, please.
Oh, sounds like we are about to
get back started.
Resume testimony.
So as we have been going through this testimony, slowly continue.
Mr. Gordon, the file placed in front of you marked as AG 34. Is there any search warrant inside this file?
There is no search warrant inside this file.
Are there any emails between the FBI and DPS inside this file?
There are no emails between the FBI and DPS in this file.
Did you notice any victim information inside this file?
I did not.
And if the redacted FBI brief had been released to one requester, it would be released to other requesters?
That's correct.
And you've had a chance to look at this file now, correct?
Yes.
And at the back of it, you'll see that, well, let's walk through it. So I think you've testified that based on this file before you, does it appear that OAG sent a notice to the FBI about this request for their redacted version of a brief?
Yes, it does.
Did the FBI respond?
Yes, they did.
And I want you to take a close look at their response brief, and specifically the last page under the signature line. It's the last page of the file. Are you there?
Yes, that's page 6 of the draft.
Witness needs to stay close to the mic and speak up.
Does it indicate that the version sent to Mr. Larson was redacted?
Objection, Your Honor. The counsel is mischaracterizing the evidence and honestly misleading the witness. The document that she is...
You may answer the question.
On this brief, it does not say redacted after the CC list to Mr. Larson.
And this brief was filed by a Mr. McPhillips from the FBI, is that right?
That's correct.
And from the front of this brief, was it filed, and it's actually marked as received by Open Records on or about June 18th, 2020? Do you see that?
Yes.
And then I want you to look immediately in front of this brief is a copy of the redacted brief at issue. Do you see that?
I'm sorry, would you repeat the question?
Yeah, if you keep flipping forward in the file, the next thing you see is a copy of the blacked out brief that the FBI had filed first.
Oh, I believe that's, I don't see in this.
The Bates at the bottom of the page I'd like to direct you to is 49982.
49982. Oh, yes, okay. That's the last page of the redacted version?
It's the last page of the brief that the FBI filed in May of 2020, right?
That's correct. I'm sorry, I was looking for the version that was actually redacted. There's no redacted version.
I apologize. There is no redacted version in here. And when you look under the signature, first, who signed this brief from May 2020 for the FBI?
Matthew Phillips.
So the same Mr. McPhillips?
Yes.
And underneath his signature line, what does it indicate next to Mr. Larson's signature? I mean, next to Mr. Larson's name on the copy list?
Next to Mr. Larson's name on the copy list, it says it was redacted.
So the first brief was sent to Mr. Larson, redacted. Is that what that represents to you?
Yes.
And so the second brief, the June 2021, based on the documents before you, was that redacted when it was sent to Mr. Larson?
It does not indicate that it was redacted.
Does that indicate to you that the FBI provided a copy of this brief directly to Mr. Larson?
Objection, leading.
Sustained, rephrase your question.
What does that indicate to you?
That indicates that they provided the same copy of this brief that they provided to DPS, not unredacted.
And I want you to take a look at this June 2020 brief and tell me how it compares to the May 2020 brief.
They look very similar. There is some different language certainly at the beginning, but they look very similar.
Other than the first paragraph, they are very similar.
Yes, that's correct.
So based on the documents in this file, does it appear that Mr. Larson that the FBI provided this information itself to Mr. Larson?
Yes.
And the very front of this file is the decision issued in this case. It starts with Bates 49954. Do you see that?
I do.
And you just looked at the FBI's June 2020 brief addressing whether or not that blacked out brief should be released to the public, right? You just looked at it?
I did.
Did it anywhere in there argue that their redacted brief should be withheld from public disclosure?
No, it looked like the arguments applied to the documents that were issued in the underlying DPS file.
And so when that happens, when the comments don't address the information being sought, what, in your experience in ORD, happens in a file like that?
In that case, we would not apply the exception to the documents that are submitted. We ordinarily, because this opinion was done by opinions, they use slightly different language than us, but we've got boilerplate for that type of circumstance. Either that the entity that submitted the arguments is arguing against the release of information that was not submitted to our office, or that the arguments that they've submitted don't apply to the information that is at issue. Because we have a presumption of openness, there has to be an exception to disclosure in order to withhold the information. And if it's a discretionary exception, it wouldn't be applied to information that they don't seek to withhold. If it's a discretionary exception, they have to seek to withhold it in order for the exception to be applied to it.
And the FBI, so the FBI just didn't address their redacted brief at all, based on this file, is that right?
That's right.
Which would result in what, ultimately, for the requester?
That would result in the information, that would result in the arguments that are raised not being addressed to the information for which there are no arguments. And if there are no other arguments, then the information would be released.
Okay, so I want to make sure we all understand what your testimony has been here today. So we had the first request to TSSB in the fall of 2019. Was any information disclosed to Nate Paul as a result of OAG's ruling?
No.
Then we move on to the big request to DPS in the spring of 2020. Was any information released to Nate Paul as a result of that ruling?
No.
And then we get to this third request. And what we see is that the FBI provided a copy of the brief directly to the requester itself. Is that right?
Objection,
right.
leading.
No.
Overruled. Repeat the question and answer.
We get to this FBI request for their blacked out brief. And what we see is that the FBI directly gives a copy of the brief to the requester, to Nate Paul. Is that correct?
Objection, Your Honor. It should be made clear for the record that we are talking about two different briefs, one in May and one in June. And the one in June, yes, there's no dispute. The FBI provided that to Nate Paul's counsel. That is not the one that contains the sensitive information that we have been discussing.
Clarify.
Of course.
I sustain the objection. Clarify.
What we're seeing from this file is that the FBI provided a copy of its June 2020 brief directly to Mr. Larson. Is that right?
Yes, that's correct.
And you've also testified that that June 2020 brief is very similar to the May 2020 redacted brief, right?
Yes, that is correct.
And that ultimately, because the FBI did not address why their redacted brief should not be released to the public, it was released.
Objection, leading.
Sustain. Rephrase your question.
What was the ultimate outcome of the opinion on this FBI request related to its redacted brief?
The opinion concluded that the unredacted brief could be released to the requester.
And you reviewed that brief?
Yes.
And you did not see any mandatory exceptions within that brief that would require OAG to apply its own redactions before release?
That's
Objection,
correct.
leading.
Overruled.
That's correct.
And after this ruling in August of 2020 on the FBI brief, do you recall one way or another if Joe Larson, on behalf of Nate Paul, continued to seek information from public safety agencies through public information requests?
Yes, he did.
And how do you know that?
He continued, well, he continued to pursue complaints against the Texas State Securities Board all the way through September of that year, seeking to obtain documents that TSSB was withholding from him in the context of Public Information Act requests. So then that continued, throughout the summer and into the fall.
And after ORD rules on a request, what does ORD do with the documents that the governmental agency provided to you to make your ruling?
We send the documents back to the governmental body.
You don't keep a copy?
No.
Those are all my questions for this time. Thank you.
Thank you, Ms. Collins.
Examination, Your Honor.
Yes.
I'm so sorry. One thing, we are moving for admission of HM 46 and AG 34 based on this witness's testimony.
Your Honor, same objection. All we're trying to do is protect the sensitive law enforcement operations, who was involved, when emails were sent, what the subject of those emails were, what the FBI's operations plans were, how they work with the State Securities Board, the FBI, the DPS. If that information can be redacted, no objection.
Hold on. We've discussed this at length. He testified there was nothing confidential. The FBI could be here. They could be called.
Yes, Your Honor, or Mr. President, yes, that's correct.
Either one, doesn't matter.
Okay, yes, sir.
But they're not here.
They're not, however, I would like to, for the record, remind the court that it was Mr. Bangert's testimony opposite to Mr. Gordon's.
Your Honor, I'm going to insist that she not say testimony of another witness in front of this witness.
Okay. Both of you, just stop for a moment, okay?
Again, continuing testimony from Justin Gordon. Direct examination of this witness has just concluded. Justin Gordon is the Open Records Division Chief for the Texas Attorney General, and we are back to the same argument that has been happening with House management prosecutors vigorously arguing that a document compiled by the FBI about their investigation into Nate Paul should not be made public, but at the same time, Team Paxton and his attorneys arguing that this information is already in the public domain. There is nothing that should preclude it from being entered into evidence as part of this proceeding that is happening right now. So Dan Patrick, the presiding officer, Lieutenant Governor of the state, obviously, seemingly going along with Paxton's defense team that he's citing testimony from Mr. Gordon that the document is public and therefore should be entered into evidence. Again, this document is the source of allegations against Kim Paxton relating to whether or not his office leaked, for lack of a better term, information to Nate Paul that contained sensitive law enforcement information.
No misunderstanding or misstatement here.
Jurors, please take your seats again.
I just want to make sure that there's no misunderstanding here, that you have a complete copy of those files in front of you, and you can see for yourself that there are no copies of search warrants, there are no copies of the actual emails within those files, which appear to be the documents that counsel is concerned about, and I just want to make sure that's clear for the record, that those documents are not in those files.
And we have reviewed them while up here, going through this testimony. Is it your representation as an officer of the court that this document has already been released to the public?
Yes.
Both documents?
Yes.
And that was the testimony?
It was.
I have to overrule your objection. We'll admit into evidence AG 34, and OAG Exhibit 46.
That should be HM 46 and AG 34,
I'm sorry.
Your Honor.
HM 46, yes.
Thank you, Your Honor. Those are my questions for now.
Yes. Your witness.
Good afternoon, morning, Mr. Gordon.
Please state your name for the record for the.
Leah Graham. You talked about this decision being fact-specific. Do you recall that testimony?
Yes.
So let's talk facts. The requester in this case was Nate Paul's lawyer, correct?
Objection, speculation.
I believe that same testimony was elicited on direct that Joseph
Overruled, go
Larson.
ahead.
Correct.
We did not know that at the time. It's become apparent that that is the case now, but we did not know that at the time.
In your original opinion, as it relates to the request for the full release of the DPS file, was that it should not be released and that the law enforcement exception applied. True?
That's the big DPS file that we're referring to.
Yes, sir.
The original draft on that, I believe, did just address it under the law enforcement exception.
And that was your opinion that it should not be disclosed under the law enforcement exception, correct?
No, that was not my opinion. That was just the first draft that was on the ruling.
Who drafted the first draft?
I'm not sure if that was the drafter on the ruling or if that was me. I don't remember.
You had direct conversations with Ken Paxton about this specific request for a full copy of the DPS file, true?
Yes.
He made it clear to you that he wanted to find a way to release the documents that Nate Paul's attorney was requesting, true?
Objection, Your Honor. That's improper testimony through this counsel, assuming facts that have not been addressed with this witness.
Your Honor, this testimony has already been elicited.
Overruled.
True?
No.
Mr. Paxton did not summon you to his office to talk about this file?
Yes, he did.
He did not put pressure on you to either not rule against the requester or to release the information?
No, I would not classify it as pressure. The decision that we made was not.
Sir, I appreciate that. I'm not asking you what the decision was made. I was asking about your conversation with Mr. Paxton. He had one of two things that he wanted to occur. Either release the information or at a minimum, figure out a way not to rule against the requester. True?
Same objection, Your Honor, assuming facts not before this witness.
Sustained.
In your conversation with Ken Paxton about this particular DPS file, can you recall any other time when Mr. Paxton directly came to you and got involved on a DPS open records request?
No.
Ultimately, you did exactly what Mr. Paxton wanted, correct? You did not rule against the requester, Nate Paul's attorney, true?
Again, objection, Your Honor, assuming facts not before this witness.
Overruled.
True?
I'm sorry, could you repeat the question?
Yes, sir. Ultimately, the opinion was not to rule against the requester, which was exactly what Ken Paxton was pressuring you to do, correct?
Again, Your Honor, I'm going to object. She's now mischaracterizing this witness's testimony. He said he was not pressured.
Sustained.
By not ruling, you were not ruling against the requester. By making a no decision, that's not ruling against the requester, true?
That's correct. We didn't rule against either party, the requester or the governmental bodies at issue.
Now, earlier you said that the OAG decision not ruling against Nate Paul's attorney, quote, tilted the scale in terms of how a court would ultimately decide whether or not to rule on the disclosure of that information. True?
No, if I said that, I may have misspoken. We did not want to tilt the scale. We didn't want to tip the scale either way. We wanted to maintain the status quo and allow the court to review it completely de novo without our opinion, which is due great weight, tilting the scale based on the procedural requirements.
Withholding the information would have been detrimental to the requester. That's what you said on direct. Do you remember that?
I'm sorry, could you repeat the question?
You said withholding the requested information would have been detrimental to the requester. Do you recall that testimony?
I'm going to object, Your Honor. I don't recall that testimony either, so mischaracterization of his testimony.
And I'm happy to put her on the stand. I'm asking the witness if he recalls his testimony.
We can check with the court reporter.
I have a quote. It would have been detrimental to the requester.
Okay. I'm going to overrule. You can answer yes or no.
Yes, it would have concluded that the information could be withheld.
Now, on June 8th, after the opinion came out, Joanna Ward. Do you know who that is?
John Award?
Yes, sir.
Yes.
Okay. On June 8th, she was asking if you still had the file in your possession. Do you recall that?
Yes.
And the file she was referring to was the entire DPS file, correct?
Yes.
And within that file is one part of it would have been the probable cause affidavit that Nate Paul was looking for, correct?
No. I believe that, if I'm not mistaken, I think that was after the ruling had been issued.
It is, sir, but that's not my question. Included within the DPS file would have been the probable cause affidavit that Nate Paul was looking for, true?
No.
The probable cause affidavit would not have been within the DPS file.
Not after we issued the ruling, we would have sent the documents back to DPS.
But by June 8th, after the decision was released, do you recall Joanna Ward emailing you and specifically asking you if you still had it, it was still checked out to you, and asking when you were going to return it? Do you recall that?
Yes.
We talked a lot about precedent and what should be publicly disclosed. You would agree with me that a search warrant is treated substantially differently than a probable cause affidavit or search warrant affidavit in terms of whether or not that should be released to the public, correct?
There are different exceptions that can apply to those, but I would not characterize anything as what can or should be released to the public. It needs to have an exception that applies to it. But both can be released to the public. A search warrant affidavit is more likely to have an exception that applies. They're not automatically confidential.
Correct. No further questions, Your Honor.
Redirect.
Very briefly, in any of these requests, could either party have filed a lawsuit challenging the outcome?
Yes.
Did anyone file a lawsuit for the outcome of the FBI brief ruling request?
No.
That's all I have, Your Honor.
And just so the court knows, because it has been unusual, either side can ask questions from the podium or their tables in case anyone's asking. Can the witness?
Requires no redirect, Your Honor.
Pardon?
Witness requires no redirect. Recross.
Can the witness be excused?
Yes, Your Honor. Thank you, Mr. Gordon.
Am I released, Mr. President?
I'm checking with the House. Yes, you can be released. Thank you. Vince, we'll call their next, no, we're going to take a break. Sorry. We'll call your next witness after a break. How about 5 minutes after 10? 20-minute break?
5 minutes after.
11. Sorry. We passed the 10 hour. 5 minutes after 11.
And with that, Ashley, we have now heard from the first defense witness in this case. His name is Justin Gordon. He works within the Texas Attorney General's office. He is the chief of the Open Records Division. Again, just going back in time, there had been some conversation about what evidence and what witnesses the defense may put on, and even if they would, in fact, do that. But we are clearly seeing this morning that they do very much plan to go forward with their case. This after what was, again, to us, a striking moment yesterday evening, during which they filed a motion for what is called a directed verdict, meaning that they stated that they did not believe that House management prosecutors had submitted or had presented sufficient evidence for the case to even go forward. The House impeachment managers had a document, a response that clearly they had drafted. They were anticipating, by all accounts and by their own actions, that the defense would seek a directed verdict. Those motions stood for about an hour before they reconvened, and Dan Patrick announced that they had withdrawn that motion. A lot of backroom conversation pertaining to whether or not they would have had the votes to end this trial prior to the defense putting it on. But certainly, given the fact that they did not bring this for a vote, we do not know how they would have voted. It would have taken 16 senators to stop the trial, to have that directed verdict, but that is not what happened. That has given rise to the belief that maybe they did not have 16 votes, just in terms of an informal counting, whether or not they would have reached the threshold, the majority threshold, to obtain that. So that's the backdrop for what's happening this morning with regard to testimony proceeding in the case this morning. Again, the clock is ticking, and so I think the defense had, what, Ashley, about 8 hours when we started the day today?
They did. So the defense went into this day with a clear advantage in terms of timing. The defense had 8 hours and 38 minutes to present its case. That's compared to the House, which had just slightly more than 2.5 hours for cross-examination of the defense's witnesses.
And Ashley, it'll be interesting to see how this all plays out, but we could get into a situation, it is conceivable that we could get into a situation where the defense still has time to to call witnesses and to put on evidence, but that the House prosecution runs out of time to cross-examine those witnesses. And that would certainly be a sight to see if that were to happen. They would be unable to challenge witnesses being put on by the defense.
And you have to think that it could certainly be.
It seems conceivable.
It's conceivable that could be a part of Tony Buzbee's strategy. I mean, we know him to be
shrewd.
And I was going to say an experienced legal mind in terms of strategy and, how to play the game, if you will, in a trial like this. And this is not something, frankly, that these attorneys are used to. They're not used to having time limits on how long they are allowed to present evidence. They are used to being able to present their cases for as long as they, would like. And so this is certainly a different realm for them to be walking through and to be doing. And so, I think one of the things you also notice, though, is that the cross went quickly. Let's get to the points that we need to get to. Let's make our points. We'll get in, we'll get out. And then also seeing the House, sort of take its time with the objections, which is one of those things that would continue to run out the defense's clock. As we saw, the defense objected far more. I mean, granted, we're in one witness.
Yep.
But the defense objected, at one point it was when Anthony Oso, the defense attorney, was going, it was a nonstop objection for every single question and word coming out of it. And that, again, runs down the clock. So it will be interesting to see what strategy.
So the House prosecutor, she was objecting. I mean,
she was. That's what I'm saying.
She was not as vigorously.
Not as vigorously, but she is objecting, and so I'm curious to see if they will continue to object. Even more so as we continue to see these witnesses, and also because you can use those objections to kind of
burn up.
Well, not only burn up time, but make your case as to why something can't be said. So perhaps what you can't say in cross, you can try to argue in an objection. And so I think it'll be interesting to see if they use that strategy at all, to move forward. We are seeing on your screen there Senator Angela Paxton get up and leave her desk, the wife of Ken Paxton. And certainly I think a lot of eyes were peeled on her yesterday as we prepared and thought we were going to hear from Paxton's mistress.
Not only that, but we did hear testimony, extended testimony from Drew Wicker, who is a person well known to the Paxtons. He was Ken Paxton's executive assistant. And had obviously a very close relationship to Ken Paxton. In fact, he testified that he spent more time with Ken Paxton than Angela Paxton, but a very close relationship between Drew Wicker and the entire family. And he spoke directly to this allegation that Ken Paxton, the Paxtons, received home remodel repairs from Nate Paul that were paid for by Nate Paul, and Drew Wicker talking about overhearing conversations in which Nate Paul's name, the name of Nate was invoked in terms of the financial implications of that project. Ashley, the constitutional bribery is one of the main underpinnings. That article is one of the main underpinnings of this whole case.
Well, because that article and Article 9, which is also a constitutional bribery article, those are sort of, that's, I think, the articles that got the attention, frankly, of the Republican members of the House of Representatives who are not on the, are not part of the General Investigating Committee. I want to go back to something you brought up about Drew Wicker, because you mentioned that he is close, you know, spent more time with Ken Paxton than his own wife, that this is someone who was very close with inner circles, traveled with him, worked with him.
Kept his calendar.
And granted, Ken Paxton was, you know, to his testimony, dodging his security detail, changing his calendar, changing his meetings without telling him. But worth noting, perhaps, that he only saw Paxton with Olson once.
At an Omni Hotel.
At an Omni Hotel, getting out of an elevator, and that, you know, he heard them talking. They were talking very loudly when they were in the hotel. Not an angry conversation. He just said a lively conversation. That he only saw them together once, and she scurried out of the hotel when it opened. And the you know, Ken Paxton, on the other hand, greeted him and said, "Hey, I'm headed to the gym." And so it also perhaps makes you wonder, well, if the person that was closest to Paxton only saw him with this woman once, you know, how interesting is that? However, we know, and it has been testified to, there was other situations, for instance, with Missy Carey, where she overheard Laura Olson speaking in a restaurant, telling some things about Ken Paxton that were not readily known to people, and that Paxton confessed to them that he was having an affair. That's why you hear us refer to her. I just want to say this too, kind of pulling back the curtain a little bit. We refer to her as the mistress because it has been testified that she is. This is not new claims or accusations. Right. Her name is not a new name. This is sort of, you know.
And it seems clearly documented.
Yes, clearly documented. No one is denying.
She's not an alleged, mistress.
And you know, there's many more reasons why we use that term, but just to be clear, that is, you know, why we say that. But the absence of her testimony would certainly put Article 9 into question. Article 9 alleges that she received a job from Nate Paul, you know, Ken Paxton had been helping Paul with this investigation, and so she received a job from Paul and then was able to move from San Antonio to Austin to be closer to Paxton, and we certainly haven't heard anything about that. I think
basically no
we've
information.
Heard nothing.
About that, how that employment came about, what she would,
if that employment happened, frankly.
Yeah, exactly.
Yeah,
yes,
I mean,
we know outside of this proceeding that it happened.
But the senators are to be judging these articles,
facts presented
not
in
on what they have seen beyond this, but only
the
on
case
what
that is made during the impeachment trial.
And we've not heard that at all. And really, Drew Wicker's testimony raised questions, frankly, about the payment of the kitchen renovation.
And the timing of the payment really came into focus yesterday.
Yeah, let's talk about that, Tony.
Well, we heard a lot of testimony, particularly from Tony Busby, who is cross-examining Mr. Wicker with regard to the timing of the payment. And essentially what was revealed during the cross-examination, according to Mr. Busby, is that the Paxtons received an invoice from a company called Cupertino Builders on September 1st.
No, the invoice was on October 1st.
The invoice...
That they actually received the invoice.
On September 1st, but paid it October 1st.
Well, remember, the invoice, the metadata showed the invoice had not
Well, I haven't gotten to that, yes.
Okay. Well, then how did they receive it if it wasn't created?
That they were paying the invoice.
Yes, they were paying.
On October 1st, pursuant to the invoice that was issued September 1st. But then we saw the House prosecutors say, well, actually, that invoice was not created according to the metadata until October 1st.
Right, and so that he said, I want to go back to it and we'll flesh this out a little bit, because the timing all became very interesting. Kamek testified.
And muddy.
It became very muddy, clearly from our conversation that we're having right now about it. So Kamek testified that this renovation of the Paxton's home was happening because in the spring there was a storm event, and there was water damage to the Paxton's master bedroom. And so
that much is clear.
That much is very clear. And I think the other thing that is very clear is that USA, who is who is the insurer of the Paxton's property, was going to give them $121,617 to pay for the renovation of the master bedroom, and that. But the bedroom was not the only thing being renovated in the house, that there was also going to be renovations made to the kitchen. And so this is where things really, really, really get muddy, is that on September 30th is the day that Jeff Mateer and other top aides in Ken Paxton's office sent an email to Brandon Kamek, who was working as a special prosecutor for the Paxtons, to tell him to cease and desist all that he was doing. Basically, Brandon Kamek had gone a few days before that and served subpoenas, grand jury subpoenas, to some financial institutions, accompanied by Nate Paul's attorney. And when the top aides in Paxton's office found this out, they sent him an email and told him to cease and desist. You need to stop serving subpoenas. Do not do it anymore. That same day is the day that Ken Paxton, on September 30th, sent a text message to his blind trust telling them to send a payment of $121,617 to Cupertino, to the construction company. 9:30, the same day, is also the day that the whistleblowers went to the FBI and reported Ken Paxton. And so the construction company, the invoice was dated September 1st. It was said it was to be due on September 30th, the day that he sent that
and
text
paid
message.
October 1st.
It was actually paid on October 1st, and that is when the wire transfer happened. October 1st is also the date that the whistleblowers told Ken Paxton, we reported you to the FBI. They told him that, but then the metadata shows
it was
that
created.
That invoice was created the night of October 1st.
So what you have is Team Paxton saying, we were just paying an invoice that we got September 1st. What's the problem?
That was dated September 1st.
Right, dated September 1st.
That's what I'm hinging on. They didn't say that they received the invoice September 1st.
That's right.
The
we were
invoice
paying
is
an
dated September 1st.
We were just paying an invoice that was dated September 1st, and then the state. Now I see the distinction that you were making.
Saying, lo and behold, it may have been dated September 1st, but that invoice was not created until October 1st, until a month later, after you found out the whistleblowers had gone. So that the prosecution sort of arguing and coming just short of saying it was a cover-up, which is why you did that.
Correct.
So certainly, again, you could be inclined to believe.
Well, but I was just about to say, here's the problem. Like, it's muddy enough that if you want to believe, well, they were just paying their invoice, then perhaps if you're a juror evaluating that, then you vote not guilty. You vote not guilty on that particular issue.
Or perhaps it's muddy enough that it's not clear beyond a reasonable doubt.
Well, and as we have discussed, that is the standard in this case. The standard that was established and voted on by the senators.
And when you think about that for a moment, Ken Paxton is now serving his third term as the Attorney General of Texas, and many of these senators have been in office, whether they are in office in the Senate or whether they were, in office in the House, started in the House and are now senators throughout his 3 terms of office of serving. And so you think that these people, because again, they're not regular jurors. They're not jurors who do not know the defendant, who do have no relationship with the defendant. They know him, and they frankly already have opinions about him. And so then those opinions, I think, have something to say about whether they were
not
inclined.
to say if they'll carry the day or not,
Right,
but
they
I mean,
have something to say about whether they're more inclined to believe him or to not have done something wrong like this or not.
exactly. And the infusion of politics, speaking of, which continues to loom large in this case. Just overnight, we know that Donald Trump posted on Truth Social, I'll just read it here to you. Texas Attorney General Ken Paxton was easily reelected last November, but now establishment rhinos are trying to undo that election with a shameful impeachment of him. Who would replace Paxton, one of the toughest and best, in all caps, attorney generals in the country? Could it be a Democrat? By the way, we know it would not be.
It would
not be, but because, or even worse, a rhino. The voters have decided who they want! ! Democrats are feeling very good right now as they watch, as usual, the Republicans fight and eat away at each other. It's a sad day in the great state of Texas. So Donald Trump, as he has previously, but decided to weigh in again at 11:58 last night.
I think that to me, if we're talking about political analysts, Tony, that does not bode well, in my opinion, for Team Paxton. To have,
like, is it a Hail Mary to call up Donald Trump and get him to
get him to sort of weigh in on this, and to also, you know, we've seen countless fundraising emails from Ken Paxton. They're sent several of them a day.
Yep.
Where, you know, it's Dear Patriots, the establishment and the rhinos are out to get me. And so it's that same language when it has been, I think, very clearly proven to these senators, who, by the way, already know who the top aides in the Attorney General's office are. But these are people who their own backgrounds, certainly, these are not just people who say they are Republicans. These are the conservative of the conservatives.
That's right, and certainly they have put money behind this campaign effort. They have named out loud some of the Republican senators they plan to target if they do, in fact, vote against Donald Trump. But Ashley, you know, we're talking about the Senate. Let's go back to May and the House. And, you know, some of those House members who voted to carry this impeachment forward are very much watching what's happening and critiquing what's happening. I mean, they feel as though they voted in favor of impeachment because they believed that the House managers and prosecution had compelling and convincing evidence that the articles should go forward. And so they voted to do that, acting, it's been linked, kind of compared to a grand jury. In other words, a grand jury decides that there is sufficient evidence. They're not voting to convict or not, but voting that there is sufficient evidence for the case to go forward. And so that is exactly what has happened.
And they're certainly watching. You know, as you are having, you know, former members of the House who are active within the Republican Party of Texas now, you know, certainly from the GOP chair in Texas to, you know, I would say ousted, because these are people who have lost, you know, elections before, or excuse me, lost recent elections, and that's why they're no longer in the House. You know, kind of rallying the troops, if you will, to say that they all need to be removed, and also just how unlikely that probably is. I mean, just how unlikely it is that 121 Democrats and Republicans voted to impeach Ken Paxton.
And clearly, if Ken Paxton were to be acquitted, they almost certainly would face some very tough questions about their decision to move the case forward. If Ken Paxton is convicted, I think that argument still stands, but it is at that point somewhat neutered, if you will.
And then, so then it raises the question of how close will the vote be in the Senate. I think we know it was clear with the motions in terms of how lawmakers voted on just this option that they had to throw this all out to begin with. There was certainly the option to do that, and 6 Republican senators were a hard yes as in they wanted to grant those motions. They wanted to throw this out. They did not want to move forward with this. And so
for conviction, just as a reminder, 9 of 18 voting Republican senators must vote to convict Kim Paxton. And so really all eyes are on the Republicans and what they ultimately decide to do, assuming, as we have, that all 12 Democrats will vote for conviction.
Right. And I think that is a
pretty safe bet.
And also worth noting that they only have to vote on one article to remove him. So a vote to convict on one of those articles is in fact all it takes to remove him from office. And so if they find him guilty of one or convict him on one, there is a world where they do not have to vote on the others.
And there are those catch-all articles. And Andrew, I think we have those. If you can put those up, we can just walk people through those again. All of the articles right there, but you can see there are 3 sort of more catch-all articles. Dereliction of duty, unfitness for office, and abuse of public trust. Let's walk you through each of those one by one, beginning with the dereliction of duty article. It is spelled out. There it is. That Ken Paxton violated the Texas Constitution and his oath of office by engaging in acts described in one or more articles. So that is one of the more, I guess, sort of catch-all articles. But there are others as well, including the very last one.
Yeah, there's actually
more than
I would
3.
say
Well,
there's
3.
more than 4. We've been saying kind of 4. There's actually more of them. The catch-all articles really start with Article 14, and that is Article 14, which alleges a conspiracy, an attempted conspiracy, that Ken Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more of the articles. So that is a catch-all. If you think that Ken Paxton did anything that is alleged in any of these articles of impeachment, you would have to find him guilty for this. The next one is Article 17, and I said 14, and excuse me, that's 16. So Article 17 is a misappropriation of public resources, and it just accuses Paxton of misusing his official power by causing his employees to perform services that benefited him directly or and the benefit of others. It's not named others, but we certainly know that the other in all of this is Nate Paul. Article 18 is what Tony has already so eloquently told you about, that he violated his oath of office by engaging in acts. So even if you think he did any of it, that was a violation of, his oath of office. And then Article 19, unfitness for office. And this is saying that Ken Paxton engaged in misconduct of such character that would show he is unfit to run for office. And then Article, 20 is,
which
I
is
would
kind
say
of the grand one.
Grand overarching.
I'm just going to read it here. We've got the bullet points, but just for a direct quote. While holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of the Attorney General into scandal and disrepute to the prejudice of the public confidence in the government of this state, as shown by the acts described in one or more articles. So that's the grand, the big catch-all,
And
like the capital C catch-all.
Yeah, and that's because it alleges that he either used or misused or failed to use. So whether you think he did something if you think he did something wrong or if you think he should have done something but didn't do it, I mean, that is it right there. And so you can see that the senators are returning to their seats. Dan Patrick returning to the dais about, at this point, 5 minutes later than they were supposed to. They're supposed to break till 11:05.
Which is not uncommon at this point. Though,
No,
let's
certainly
be
not.
clear. I mean, my estimation is that Dan Patrick is running a fairly tight ship in this case.
In terms of the time.
In terms of the time, yes.
Absolutely, in terms of the time is, saying, but we say a tight ship to be a fly on the wall when they were discussing whether or not Laura Olson would be permitted to take the stand. Certainly would have been an interesting conversation. And it's a conversation I think so many people wanted, so many Texans wanted to hear. They wanted to hear what she was going to have to say. And so for Texans to not even get to hear why she wasn't going to get to hear, which is not, again, I point, in a criminal case, in a civil case, conversations that are had outside the presence of the jury are still had in the presence of the public.
Also similarly in a civil or criminal case, the witness would not be allowed to tell parties without getting on the stand, I'm going to plead the fifth, I'll see you later. And that falls differently in civil and criminal courts. In civil courts hearings, the decision to plead the fifth can be seen by jurors as unfavorable, but in a criminal trial, the decision to plead the fifth cannot be viewed as by jurors as unfavorable. It has to be not counted or not considered. So,
but this is certainly not a criminal trial.
And Laura Olson, as far as we know, is not accused of any crime or under investigation by any crime.
But just she believed that whatever she was going to have to testify to was going to incriminate her.
Which is the standard for the ability to plead the fifth.
That you personally feel as though you are going to incriminate
create criminal liability for yourself through your testimony. You can't say, I'm going to plead the fifth to protect my friend or the man I am having an affair with or had an affair with or family member.
Well, and it's just self-incrimination. This was the point I was chatting with Adam Lowy yesterday, a local Austin attorney, and he kind of said people think about it as what does self-incrimination mean, and it doesn't always have to be criminal, that it can occasionally
thank you, Your Honor.
be.
Chris Hilton for the Attorney General. The next witness is Austin Kinghorn.
Bailiff, please bring in Mr. Kinghorn.
Okay, so we were
Honor,
listening.
While Mr. Kinghorn's coming in, I just want to clarify for the record, for the jury, and for the public. At the end of the day yesterday, we had called Professor Michael Gerhardt, who's intended to be one of our expert witnesses. Last night, the court ruled that the expert testimony we were going to provide would not be heard. And so to the extent there was confusion, I just wanted to make the jurors aware and the public aware that that was the court's ruling, and that's why those witnesses aren't here.
And the court ruling was based on objection from the House under rule such and such.
Yeah, yes.
And we took about an hour to deliberate and look at all the questions.
That's right. I apologize
We ruled in favor of the House on that.
Just wanted the public to be aware, that's right.
And you were very kind to pull them from your witness list.
Thanks, sir.
Mr. Kinghorn, I believe I already swore you in the group. You may be seated. Speak loudly and closely to the mic. Thank you.
Austin, good morning. Thank you for being here. We both need to speak slowly and loudly into the microphone. I am told you've testified in this chamber before the Senate, correct?
Yes, I have.
Okay, so you know the acoustics in here can get a bit weird, especially for our folks in the back.
That's correct.
So please just introduce yourself to the jury and tell us about your career.
My name is Austin Kinghorn. I'm the Associate Deputy Attorney General for Legal Counsel at the Office of the Attorney General. Would you like me to go back from the...
Yeah, sure. Why don't, if you could please just start with law school, walk us through what you've done up to the present day.
So I graduated from Baylor Law School in 2010. After that, I did a clerkship on the 14th Court of Appeals for then Justice Jeff Brown. I did a stint in commercial litigation. Yes, sir. I did a stint in commercial litigation after that, primarily doing insurance defense. After that, I went to work for the AG's office in the Civil Medicaid Fraud Division. When Justice Brown was elevated to the Texas Supreme Court, I went to work for him again as a staff attorney. I worked at the court for about 6.5 years in that capacity for Justices Brown and later Justice Jane Bland, and then came back to the AG's office in the General Counsel Division. From there, I was promoted to General Counsel, and then most recently to the title that I hold now.
Thank you, sir. And tell us a little bit about your work for the Attorney General and your current roles, both as General Counsel, Opinions Committee, and your current title.
Right. So as the Associate Deputy for Legal Counsel, I'm over 2 divisions. It's a General Counsel Division and the Opinion Committee. In that role, I am both the Division Chief of General Counsel and General Counsel for the agency, and also Chair of the Opinion Committee.
How many employees do you oversee?
19.
And are you proud of your time at the Attorney General's office?
I am very proud.
I think this is a bit of a silly question, but it's come up a lot. Are you a rhino? Do you know what a rhino is?
Yes, I do. I've been called a lot of 4-letter words. That's not one of them.
What are your politics? Are you conservative?
Yes, I am.
Again, I think it's a silly question, but it's being asked. On a scale of 1 to 10, how conservative do you think you are?
11.
Fair enough. What I'd like to do today with you is go through these articles of impeachment, see if there's any perspective you can provide as to each. And I appreciate you being here helping explain the work of the agency for the jury. So let's start with Article 1, which relates to the Mitty Foundation and the intervention into that lawsuit. Were you directly involved in that lawsuit or that intervention in any way?
I was not.
Okay. But are you familiar with EAMs?
Yes, I am.
Unfortunately, we've talked a lot about EAMs during this trial. What's your understanding? What is an EAM to you?
An executive approval memorandum is a document that the agency relies on to seek and attain executive approval of various agency actions or engagements.
And do you receive EAMs as part of your work?
I do. I probably receive 1 or more a day.
What do you do if you have concerns about an EAM?
If I have concerns about an EAM, typically the practice is going to be to reach out to who circulated the EAM and, engage with that person directly, try to flesh out the issues. Sometimes it's simply a matter of correcting something in the EAM and recirculating it. So, the first step is always just get in touch with the folks who are asking for the executive action and connect and make sure you have an understanding of what's going on.
If you get an EAM that you're concerned about or you're proposed a course of action that you don't agree with, do you just go ahead and sign the EAM anyway?
No, I do not.
Okay. So what does signing the EAM signify?
That would signify that you have reviewed the EAM, you reviewed the legal authority in it, the explanation of the rationale for the action that's being sought, and that you approve of that action being taken.
So if someone at the Attorney General's office signs an EAM, does that mean they've approved that action?
That's correct.
What about, let me ask you this, does the Attorney General have to have an EAM that's fully approved by his subordinates before he takes an action?
No, he does not.
Why not?
The Attorney General's authority and the First Assistance Authority flow directly from the Texas Constitution and from statutes, specifically Government Code Chapter 402. The EAM process exists to vet certain proposals, but it is ultimately not binding on the person or persons who actually possess the constitutional executive power to act as Attorney General or on behalf of the Office of the Attorney General.
So just to make that clear, the Attorney General has the legal authority to act without an EAM approved by his subordinates?
Absolutely.
Okay. Does that include the authority to sign a contract?
Yes, it would.
Okay. Let's look at an example of an EAM. Can we pull up House Exhibit 62, please, Mr. Arroyo? Your Honor, I believe this has already been admitted into evidence, and I'm going to try and go electronic today, so we'll see if it works. And Mr. Arroyo, if you could just zoom in on the signatures on the top of this EAM and maybe capture the subject line as well. Have you seen this EAM before, Mr. Kinghorn?
Yes, I have.
Okay. And which EAM is this?
This is a EAM requesting approval to intervene in the Mitty Foundation litigation.
You weren't a signatory on this EAM, correct?
No, I was not.
Okay. But let's look at the first signatory. That's Mary Henderson. Who is that?
Mary Henderson at the time was in our financial litigation division, and she held a senior attorney role in that division.
And what does her signature on this EAM indicate?
That would indicate that she has approved of the action described in this EAM, and it looks like she's the one who actually circulated this EAM.
Why do you say she's the one who circulated it?
It says from Mary Henderson, and also she's the first signatory. So typically the first signatory on the document, the lowest signatory would be the person who actually routed the document for approval.
So does this indicate that Mary Henderson and Kat Day actually authored this EAM? Is that what this says to you?
That's likely the case, yeah.
Do you know whether the Attorney General ever spoke with Mary Henderson or Kat Day about this EAM?
I do not know.
Okay. Who's next on the signature line? Who's Josh Godby?
Josh Godby at the time was the division chief for the financial litigation division.
And what does his signature here indicate?
That would also indicate approval of the action that the EAM is seeking.
And who's next up the chain on this EAM?
That's Darren McCarty.
What was his role at this time?
At the time, he was the Deputy Attorney General for Civil Litigation, so you'd see his name a lot on EAMs like this involving requested courses of action in active litigation.
And again, I want to be clear about what his signature means here. When he docu-signed this EAM, what does that indicate to you as General Counsel of the agency?
That indicates approval of the action that is sought by the EAM.
And same question with Mr. Mateer. What was his role and what does his signature here indicate to you?
Jeff Mateer was the first Assistant Attorney General at the time, and his signature would indicate approval of the action that EAM seeks.
And would it be your expectation that all of these people who signed this EAM have read it?
It would. I mean, that is certainly the point.
That's what you normally do within OAG, right?
Correct.
And would it be your expectation that they understood the memorandum before they signed it?
I would not sign an EAM that I did not
Objection, Your Honor. Question calls for speculation.
I'll move on. Thank you, Mr. Roy.
Sustained. And
all right, let's move on to talking about Article 2. That's about the foreclosure guidance letter. It's been called a lot of things in this courtroom. That's what I'm going to call it. Do you understand what I'm referring to? Are you familiar with that letter?
I do understand and I am familiar with it.
Okay. Did you work on that guidance letter personally?
In a very limited capacity early on, I performed some very perfunctory research on it. I never participated in the drafting of the letter itself.
Okay. Who asked you to do that research?
Ryan Vassar.
And did you form a conclusion as to what was the ultimate outcome in your limited role?
As memory serves, I didn't form any firm conclusions at the time. I performed a couple hours, maybe 3 hours of research, and really just had enough time to kind of come up with some general parameters of what the issues were. And Mr. Vassar and I had a phone conversation about what we had found so far in our respective research, and he took it from there, and I never had another conversation with anyone else about the letter moving forward.
Did you see the letter once it was ultimately issued?
Only when it was issued, yeah, when it went up on the website.
Right, so to be clear, you weren't involved in the drafting process, so you don't know how they got from A to Z on that.
That's right.
Okay, but you saw the final letter.
I did.
Did you agree with the analysis and the conclusion in that letter?
I do.
Objection, Your Honor. Relevance.
Overruled.
And just as sitting there, as you sit there today, can you briefly explain what that letter does in your view? Well, or rather, let me rephrase. Can you explain the conclusion of the letter?
The legal conclusion?
Yes.
The legal conclusion essentially was that under the circumstances of COVID at the time, with 10-person restrictions on in-person gatherings, that there was a possibility that a public sale, as defined by statute, that necessary element to proceed on a foreclosure wouldn't be satisfied if you didn't have a situation where anyone who wanted to be a bidder on a property that was under foreclosure would have an opportunity to bid on it and thus get the best, most fair value for the property.
Let me make sure I understand each piece of that. So you mentioned the public sale issue. That's a requirement out of statute. Did I understand you?
That's right.
Okay. And you mentioned a bidder being excluded. Why would that be the case?
Sorry, could you repeat that?
I thought you mentioned the 10-person requirement might result in a bidder not being able to participate in a foreclosure sale. Why would that be the case?
Correct. So normally these sales are open to the public. Anyone who wants to go bid on a property can, and that of course has the effect of increasing the price, typically. And the COVID restrictions there at the time, the governor's executive orders only permitted 10 people to gather at once in what was considering, I think the nomenclature was at the time, a public gathering.
So to make sure I understand what you're saying, if there were bidders that were excluded, that could drive the price down at the sale?
Yeah, that's certainly a possibility.
Okay. In your view, does that letter shut down foreclosure sales in the state of Texas?
I don't have an opinion on whether it did or didn't. I do know it was non-binding and informal legal guidance.
Did you work on any other COVID-related opinions or guidance documents?
I worked on a great number of them. During my first several months at the agency, starting in June of 2020, COVID-related work was the vast majority of what I was doing.
And if you could just briefly for a minute here, explain to the jury, explain to the public, we're trying to explain the work of the Office of the Attorney General today, so explain what it was like to be working on these issues during COVID.
It was intense. It was a demanding time, as I'm sure it was for a lot of people in this room. We were on the cutting edge of a lot of novel legal issues. A lot of folks were looking to the AG's office for guidance and direction on how to respond, how to navigate the challenges that were coming forward, especially as it pertained to the governor's executive orders, which were coming out. We were often looked to for guidance on how to comply with those, what they meant, construing them, and we fielded those requests from all corners.
Was it unusual during that time to have expedited requests or to be working on short deadlines?
That is never unusual at the OAG, under any circumstances.
Particularly so during COVID?
Sure, particularly so. Everyone who came to us with a problem needed an answer, and wanted an answer, at least quickly.
Understood. Let's talk about opinions and guidance documents from the Attorney General's office more broadly. What kinds of guidance can the Attorney General issue?
Well, there's a range of options. A lot of folks in this room are probably familiar with our formal legal opinions. Under Chapter 402 of the Government Code, an authorized statutory requester may request a formal legal opinion from the OAG, and that opinion, while not binding, is a source of persuasive legal authority that courts typically will look to and consider when resolving a case. But we have other tools in our belt beyond that. Additionally, under chapter...
Before we go to the next one, I just want to clarify one thing. You mentioned that a lot of folks in this room might be familiar with that formal legal opinion. Why would that be the case? Why would these senators and some of these House members be familiar with that?
Chairs of legislative committees, senators and House members are authorized requesters under the statute.
Okay. Does the Attorney General's office work frequently with those authorized requesters regarding their requests for opinions?
We frequently work with members of the legislature on a host of issues and try to be as solicitous as possible in being helpful and giving the best legal guidance we can.
Okay. And I'm sorry I interrupted you. So that was the formal legal opinion process. You're moving on to the next category, so I apologize for interrupting.
Sure. So under Chapter 418 of the Government Code, which is the Texas Disaster Act, the AG's office has additional authority to provide legal counsel to local political subdivisions during a declared disaster. Authorized requesters include mayors, county judges, county commissioners, emergency management directors. Beyond that, the office has historically operated with the understanding that we have broad legal authority with the Attorney General as the chief legal officer of the state to issue informal guidance of public note, of public interest that would have a wide applicability to the public at large, especially in disaster situations where there's a need to get good information out to the public on pressing issues. And that authority, I think, flows directly from the Attorney General's constitutional and statutory authority as the Attorney General, as the chief legal officer of the state.
Other than the foreclosure guidance letter, can you recall any examples of other COVID-related guidance that was issued that also fell in that third category you described?
We put several guidance documents out on issues that a lot of folks are facing. Churches, private religious schools. I know that we did some opinions on access to vacation homes, and not opinions, letters on access to vacation homes in other states, where golf courses fell in terms of the governor's orders for shutdown purposes. So there were a lot of topics that we put something out there short of a formal opinion that was designed to provide generally applicable informal legal guidance to the public at large.
So it's fair to say, is it fair to say that the foreclosure letter was not unique in that regard? It was not the only informal guidance that was put out?
That's correct.
Let's look at a couple of other examples of guidance from this time. Mr. Arroyo, if you could pull up House Exhibit 105. And I believe this has already been admitted, Your Honor. Are you familiar with this document, Mr. Kinghorn?
Yes, I am.
And just very briefly, what is this document?
Objection, Mr. President. This document is not in evidence.
I apologize. I thought it had been admitted. It's House Manager's Exhibit 105, and I'd offer it if it hasn't been admitted.
We thought it was pre-admitted, Ms. Epley?
No, Mr. President, I don't believe so. We don't object. It's our document to begin with. I just wanted to make sure the record was clear.
Yeah, I apologize. I tried to get this smoothed out with counsel before we started, but yes, I offer it, if it hasn't already been admitted.
Okay. It will now be admitted into evidence. That's exhibit, what's the number, 105?
House Exhibit 105, Your Honor.
Okay, admit it to evidence.
Mr. Kinghorn, if you could, please just, to the extent that you can, please just describe briefly what this document is.
This was a general guidance document that the agency issued to houses of worship during the COVID pandemic.
Is this a full-blown opinion under Chapter 402?
It is not.
And is this a disaster council letter under Chapter 418?
No, this is not.
Mr. Arroyo, if you could show us the bottom of the page, there's a date next to the exhibit stamp. And when was this letter issued?
It says April 27th of 2020.
Do you think it was any way improper for the agency to issue this guidance?
No, I do not. And in fact, I think this is the kind of guidance a lot of folks were looking to the Attorney General to provide.
Let's look at another example.
May I seek clarification? He was confirming that the guidance in regards to the house of worship, Exhibit 105, is not something he takes issue with, correct? Not the foreclosure letter itself?
Your Honor, she can cross-examine the witness.
No, I'm clarifying.
This is my examination, and she should be able to.
You can cross-examine on that.
Okay, thank you.
Thank you, Your Honor. Let's briefly look at House Exhibit 104 next. I also thought this one had been pre-admitted. Maybe I'm wrong. To the extent that it wasn't, I'd offer House Exhibit 104.
Thumbs up.
Great. Mr. Kinghorn, have you seen this letter? Or rather, are you familiar with this letter?
Yes, generally speaking, yes.
Okay. This is a letter in response to Chairman Frank?
Yes, this is the one about the golf courses. Okay, I had to read a little bit into it.
Okay, great. Let's look at the last page, please, Mr. Arroyo. If you could just zoom in on that text, please. So this letter, was this a full-blown Chapter 402 opinion?
No, it was not.
And how can you tell that?
It's got some language there caveating that it is not a formal opinion issued pursuant to Section 402.042, which is our formal opinion statute.
It says on the letter that it is not a formal opinion under Chapter 402.
That's right.
So if someone were to say that this was a Chapter 402 opinion, they would be wrong. Do you agree?
I do.
Are you aware that the foreclosure guidance letter has substantially similar language in it?
Yes, I am aware of that.
Okay. And who was this letter signed by?
Ryan Vassar.
So Ryan Vassar signed an informal guidance letter.
Yes.
Does that indicate to you whether Mr. Vassar thought he had the authority to sign that letter? Do you think there was an issue with authority for issuing this letter?
I assume that he operated under authority to issue this letter on behalf of the agency.
Did you think a requester was necessary for the foreclosure letter?
No, I did not, personally.
Do you have any personal knowledge as to why one was sought?
I do not.
So you'd have no reason to disagree with me if I were to tell you that a requester was demanded because someone was trying to get out of doing the work.
Objection, Mr. President, I'm sorry. Counselors testifying to facts not known to this witness.
Sustain.
You can take that down, Mr. Royal. I think that's enough for Article 2. I think we're going to skip Articles 3 and 4 because I don't think you have any unique responsibility with regard to the PIA. Is that true?
I do not, that's right.
And we've heard plenty about the PIA today. But as an aside, does the Attorney General have the authority to access any case file or file in the agency?
Yes, I believe he does. He's the Attorney General.
Why does that give him the right to access any file he wants?
Well, I guess there's kind of an old saying in the legal profession that his name's on the wall. It's his agency, and he's the duly elected Attorney General. So it's his law firm. He gets to see a file if he wants to see it.
So if someone were to say that the Attorney General improperly accessed a file, would that make sense to you?
That would not compute to me.
Me neither. Can we pull up Article 4 briefly, Mr. Arroyo? Do you see the allegation here where it says Paxton improperly obtained access to information held by his office. Did I read that correctly?
Yes.
Okay. Let's go to Article 5 now. I'll take that down, Mr. Royal. Are you familiar with the contract with Brandon Kamek?
I am.
Okay. Did you have any involvement with hiring him?
I did not.
Did you have any involvement with drafting the contract or executing it or anything like that on the front end?
I did not.
Okay. When did your involvement with this particular contract begin? When did your familiarity with it begin?
Sometime later, after the contract had been terminated, I believe Mr. Kamek reached out to our office to inquire about payment on the contract for the outstanding invoices.
And when you say reached out to our office, does that mean he reached out to you as general counsel, someone in your division? Do you recall?
My best recollection is that it was a phone call to the general counsel division. I think he was looking for someone to talk to about it.
Do you remember a date for that phone call?
I don't.
Was that before or after you'd been promoted to general counsel?
I believe it was after.
Okay. And when were you promoted to general counsel?
During the month of November of 2020.
Okay. So sometime after your promotion in November 2020, Mr. Kamek called to inquire about payment on his contract. Is that your testimony? I just want to make sure I understand the timeline.
That's right.
Okay. You were made aware of this phone call. What did you do with that information?
I conferred with Leslie French, our chief of staff, on that, primarily because she had more awareness of these issues and what had been happening at the time. As I said before, I had no involvement with the contract. So she and I recall discussing it.
Objection, Mr. President. Question calls for hearsay, or he's about to get into hearsay at this point.
And let me clarify. Please don't...
Sustained.
Yeah, thank you. Of course, I agree. Please don't relay the contents of any conversation that you had with anyone else. Don't tell me what anyone said. Again, I'm just asking, once you became aware of this request for payment, what happened next? So you said you conferred with Leslie French. Please pick up there.
My best recollection on this is that at some point, a call was made to Mr. Kamek.
Objection. Anything you could state after that is going to be hearsay.
We don't know what he's going to state next, so I don't think that's true.
Overruled.
In that case, anything next is non-responsive. May he ask another question?
You can break it down into questions.
Did you reach out to Mr. Kamek?
Yes.
What was the purpose of reaching out to Mr. Kamek?
To follow up on his inquiry.
What did you want Mr. Kamek to know when you followed up with him?
Objection, Your Honor. Hearsay.
I didn't ask for what he said. I asked for what he wanted Mr. Kamek to know in response to his inquiry.
Overruled.
The purpose of the call was to inform Mr. Kamek of how he might proceed about processing his invoices under the contract.
And what were Mr. Kamek's options to get paid at that point?
There remained work within the scope of services that had not been satisfied before we could issue payment. Specifically, the preparation of a report of his findings hadn't been completed. So what I relayed to him, and I believe this was over a voicemail, was that we couldn't make payment on the contract until that commitment had been made.
If Mr. Kamek had sent you that memo that he had contracted to provide, what would you have done?
Subject to any other clerical reason that we might have to shore up, from my view, it was a payable invoice because it was a valid contract at the time that the services were performed.
Did you ever hear back from Mr. Kamek after you advised him that if he sent you the memo, he could get paid?
I did not.
Mr. Kamek never called you?
Not to my knowledge.
And again, when was this, to the best of your recollection?
My best recollection is it would have been sometime in November or later.
Let's go ahead and skip ahead to Article 7. Just briefly, are you aware of the Attorney General's Office internal report regarding the events underlying this impeachment proceeding?
Yes.
And broadly speaking, what is that report as you understand it?
That report is the findings of a 10-month investigation that was conducted internally at the Office of the Attorney General concerning the allegations that the whistleblowers raised.
Did you ever review that report?
I did.
How many times? What was the nature of your review?
No more than 3 times. I was provided a copy and asked for general feedback on the document, proposed edits, revisions, things along those lines.
Were you ever directed by anyone to make sure that the report was a sham?
No.
Were you ever directed to make sure it included false or misleading statements?
Absolutely not.
Are you aware of anyone else receiving such a direction?
Absolutely not.
What would you have done if you had identified a false or misleading statement in that report when you reviewed it?
If I had identified a false and misleading statement, I would have immediately raised that issue to the folks who are working on the report for consideration.
When was that report published?
That was August 24th, I believe, of 21.
And just to be clear, I'm looking at the text of Article 7 here. The allegation is Paxton directed employees of his office to conduct a sham investigation. Are you aware of that occurring?
I'm not aware that that occurred.
And you're one of the employees who, at least to some degree, worked on the report?
That's right.
The report was published in August 2021, you said?
That's right.
And it's been on the has it been on the Attorney General's office website continuously since that time?
Yes, it has.
So, was that before or after November 8th, 2022, that this report was issued to the public?
After. Can you repeat the question?
Sorry.
I
was
may
the
have misheard the date.
report made public before or after the Attorney General's election on November 8th, 2022?
Oh, I'm sorry, before.
It's been on the Attorney General's office website continuously since then.
That's right.
Are you aware of whether there was reporting on the issuance of that report?
There's been extensive reporting on the issues that were discussed in that report.
When did that reporting begin, as far as you're aware?
That reporting began pretty much immediately when the whistleblowers reported General Paxton as law enforcement, and it's something we've been dealing with ever since.
And the OAG report also contains the details of those facts?
It does.
Okay. And that's been public?
Yes.
On the Attorney General's website?
Yes.
You can take that down, Mr. Roy. Let's move on to discussing Article 8 a little bit. Article 8 deals with the settlement of the Brickman versus Office of Attorney General litigation. Are you generally aware of that litigation and that settlement?
Yes, I am.
As part of the agreed settlement terms in that case, are there any contingencies that must be satisfied before the settlement is fully effective?
Well, the biggest contingency would be funding for the settlement itself. I think there may have been some non-monetary considerations as well, but I think maybe the one you're asking about is the contingency of the legislature funding the requested amount.
That is the one I'm asking about. Why is that legislative appropriation of funding contingency necessary for this settlement?
Like other state agencies, the Office of the Attorney General is prohibited in the General Appropriations Act from settling a case for more than $250,000 without seeking additional funds to do that.
Does state law set out a process for seeking funding for such a settlement?
It does.
Did the Office of the Attorney General follow that process?
Yes, we did.
Do you know whether funding was appropriated?
It has not been appropriated to the state.
Has the Office of the Attorney General paid out a single dime on this settlement?
It has not.
As far as you're aware, has a single dime of taxpayer money been spent funding that settlement?
It has not.
Who decides whether that will ever happen?
At this point, ultimately, the legislature will.
The House and the Senate?
Correct.
It's up to them whether to fund it.
That's right.
The Attorney General can't force them to do that, can he?
He can only ask.
Let's pull up Texas Government Code section 554.010. Your Honor, this is just a statute. I'm not offering it as an exhibit. It's going to be up on all of the screens. Mr. Arroyo, if you could zoom in on that. And I have paper copies for the witness and the court and opposing counsel, if that would be helpful.
Now this will work.
Are you familiar with this provision in the Whistleblower Act?
Yes, I am.
Can you explain in English what the statute means?
So this is essentially a reporting requirement. There's two parts to this. When you pay out on a settlement or judgment in a Whistleblower Act case, the agency is required to essentially put together a report on that case. And following that report, the state auditor's office may initiate an audit or an investigation of basically what went into what happened with the Whistleblower Act complaint. And if the SAO initiates that investigation, then they must follow up with a report to several entities on improvements that can be made, things that can be changed to prevent this from happening again.
So let's break that down. Let's go piece by piece. If the settlement is consummated, the Attorney General's office has to do what?
It has to put together a brief memorandum describing the facts and the disposition of the suit, and it has to provide that to the state auditor's office.
Okay. The Attorney General's office has to prepare a memorandum describing the lawsuit and send it to the state auditor's office. What happens after that? What does the state auditor's office do with it?
The state auditor's office will review the report, and not later than the 90th day after that report is submitted, the SAO has the option to investigate the governmental entity or conduct an audit.
Let's just pause right there. Mm-hmm. They have the option. Has the Attorney General's office been contacted by the state auditor's office regarding this provision in connection with the Brickman versus OAG matter?
Yes.
And what's your understanding of that contact from the state auditor's office regarding this statutory audit?
We were made aware of the existence of the statute, and they just wanted to bring it to our attention in light of the settlement road that we were on to make sure that we were aware of this requirement.
The audit's coming.
That's right.
And under this statutory audit, who would have received the state auditor's report?
The Legislative Budget Board and the Legislative Audit Committee, and the governing board of the chief executive officer of the entity involved.
What would that report contain pursuant to the terms of the statute?
The SAO's report would include recommendation on changes that would be necessary to correct the problems that gave rise to the whistleblower suit.
Mr. Arroyo, could you pull up the text of Article 8, please? If I'm understanding your testimony correctly, the OAG has been notified of the statutory audit by the state auditor's office, and those findings and recommendations will be given to the legislature under the terms of the statute, correct?
That's right.
Are audits and cover-ups the same thing?
I'm sorry, could you repeat that?
Is an audit the same thing as a cover-up?
Did you say a cover-up?
A cover-up.
No, it is not. It's kind of the opposite.
If someone's trying to, I don't know, conceal their wrongful acts, should they subject themselves to an audit, in your opinion, as General Counsel of the Attorney General's office?
No.
Do you know whether the State Auditor's Office likes to conceal facts when it conducts an audit?
I do not believe that is the way they are wired.
I don't believe so either. And of course, we talked earlier, your testimony is that the allegations underlying the facts at issue in this impeachment have been reported since they happened. That's your understanding.
Correct.
You've seen reports in the media frequently about the goings-on at the Attorney General's office.
That's right.
Texas Tribune seems to have a story every other day about the Attorney General's office, don't they?
There is a lot of coverage.
Do you have any personal knowledge of Ken Paxton ever forming an agreement with Nate Paul and accepting a bribe?
I have no personal knowledge of that.
And do you have personal knowledge of anything to do with Laura Olson?
I do not.
Okay. Do you have any personal knowledge of any vast criminal conspiracies involving misuse of OAG resources?
I have no such knowledge.
If there were such a conspiracy, would you still be working at the Attorney General's office?
No, I would not. I accepted promotion in this agency at a very critical time, and I assured myself and assured my wife if there were ever anything that I saw that were illegal or unethical, I would step away. And I'm still here. I'm proud of the work we do. I'm proud to serve General Paxton. I'm proud to be a part of this agency.
Thank you, Austin. Pass the witness.
Ms. Sepley, your witness.
Thank you, Mr. President. Hi, Mr. Kinghorn.
Good afternoon.
Have you and I spoken before?
We are old friends now.
That's right. Is it fair to say that you have been my contact to get documents from the Office of the Attorney General?
That's right.
And that our first conversation went well, but subsequent ones got a little chillier?
That's fair.
Now, we played respectfully with one another, right? No one was rude?
That's right.
Okay. Is it also accurate, though, that right after I would have private conversations with you as an officer of the Office of the Attorney General, particular details of our conversation would show up in Ken Paxton's filings?
Objection, Your Honor. Relevance, hearsay, has nothing to do with these proceedings.
Sustained.
Mr. President, I don't know that I've ever seen a lawyer open up a bigger door in regards to the credibility and bias of a particular witness, and I would ask for a little latitude.
Your Honor, this has nothing to do with credibility and bias. She's asking about litigation discovery. That has nothing to do with
I
this.
sustain the objection. Try your question a different way.
Did you receive pressure from Chris Hilton or Judge Stone to provide you information in regards to our conversations?
Not at all, and I can answer your question more pointedly.
I'm certain that he will do that, so I don't want to be rude, but I want to make sure we move forward. Did you receive pressure in coming without a conversation?
Not at all.
Did you receive directives in regards to what position you should take?
None.
So the fact that you and I would have a conversation and it would show up in their filing the next day is completely and totally made up?
Objection, Your Honor. This is totally improper. All parties, all witnesses were free to speak to both sides. That was in the Senate rules that were adopted. And it is only fair that people producing discovery talk to both sides. They certainly talked to people we were talking to. We talked to people they were talking to. That's how the entire litigation of this impeachment has gone. This is completely improper. Nothing improper happened here. And she's not only attacking the witness's character, but my character and my colleague's character. This is completely improper.
Sustained.
To clarify, then, maybe it was the subjective use of a word. As opposed to pressure, did you receive incoming communications that inquired about our conversations?
Objection, Your Honor. Same objection, and this is hearsay.
Sustained.
Okay. You talked some about MIDI. Is that correct?
About you?
About MIDI. Sorry. MITTE.
MIDI, yes.
Yes, sir. You were not directly involved in that litigation?
I was not.
So mostly what you offered for us was the use of the EAM or people's signatures to validate a contract or an action, correct?
Objection, Your Honor, mischaracterizes his testimony. His testimony speaks for itself.
Sustained.
What is the purpose of the EAM?
The purpose of an EAM is to solicit and attain executive approval of an action that's being proposed to be taken or an engagement that's being proposed within the agency.
Thank you, Mr. Kinghorn. And when you personally sign an EAM, are you signing to say, I believe this is a good idea, we should proceed? Or are you signing to confer, as general counsel, there is legal authority?
You're asking about me personally?
Yes, sir.
And I would be signing generally as to legal authority.
Okay, so when Mr. Hilton asked you and you said you were giving approval, it means consistent with your job, that's an available option that we can justify, not this is my idea, I suggest we do it.
Objection, misstates testimony.
He can answer, Your Honor, if it's within his knowledge. Thank you.
I think that everyone's, depending on their role, their reasonings for going into their signature is a little different. For my role as general counsel, I'm primarily focused on whether the agency has the legal authority to take the action proposed.
And to draw an analogy then, Ryan Vassar, for example, signing Brandon Kamek's contract is approval that it's a legal justified position, not that it's the right one.
Objection, Your Honor, assumes facts not in evidence with this witness.
Sustained.
But your approval is about legal authority, yes or no?
Yes.
I'm going to turn your attention for a moment to the PIA. Are you aware of incoming public information requests as to Ken Paxton's email, Signal, or Proton?
Typically, no. If a PIA request you're referring to is directed exclusively toward the Attorney General, that's probably not a request that would come across my desk.
I think I want to be more specific. Are you personally aware of any PIA requests ever for the text messages, Signal account, or Proton of Ken Paxton?
Objection, Your Honor, relevance.
Overruled.
There's been a great number of PIC requests concerning the Attorney General's personal communication devices. I don't remember with specificity as to the specific types of communication you're referring to.
So you're telling the Senate you do not know if a PIA has ever been requested for his texts?
If you phrase it that way, then yes, I am aware that there have been PIA requests for his text.
Are you aware of PIA requests for his Proton email?
I'm not personally aware of them, or at least do not recollect.
Are you personally aware of PIA requests for his Signal?
I'm not personally aware or don't recollect at this point.
Are you personally aware that he has those accounts?
Again, objection, Your Honor, to the relevance of this. It has nothing to do with anything this witness has testified about. It has nothing to do with anything in his personal knowledge, and nothing to do with any of the articles of impeachment.
Overruled.
I do not have any personal knowledge on the use of a Signal account. In terms of, as I have reviewed the documents in terms of producing to you through subpoena requests, I have seen that there was a Proton email account that wasn't included, I believe.
Are you familiar with the fact that either the Proton or the Signal was set up by Office of the Attorney General IT staff?
I am not familiar with that.
Do you think that you should be if it's true?
Not necessarily.
Okay. Are you aware of the fact, either through a PIA request or the subpoena authority of this Senate, we were not provided any documentation related to Signal or to Proton email for business conducted on behalf of the state of Texas by Ken Paxton?
Objection, Your Honor. Lacks foundation, lacks personal knowledge. The witness has testified that this is not within his scope and that he doesn't know anything about any of these. This is an argumentative question with no foundation.
Sustained.
Did you personally respond to our discovery requests?
Yes, I did.
Did you personally have a conversation with me about Proton email?
Objection, Your Honor. Hearsay.
I don't know what to say to that, Your Honor. We're both here.
I'm going to overrule. You can answer the question.
Thank you.
Can you restate the question for me? I'm sorry.
Did you personally have a conversation with me about Ken Paxton's Proton email?
I do remember that conversation, yes.
Do you remember telling me that you knew it existed, but couldn't provide me any of those documents?
I did not say that.
You didn't tell me that you knew that there was a Proton email account, but you didn't know anything about it.
Objection, Your Honor. Asked and answered. She's attempting to impeach the witness with a conversation that she thinks she recollects. This is improper.
I'm certain I recollect it, if that helps.
Overruled. You did ask, he did answer, but overruled.
Okay, so let's try this one last time. Will you tell the ladies and gentlemen of the Senate if you provided us any Proton or Signal documentation for Ken Paxton?
Sorry, can you ask it just a little bit more slowly, just the echo is...
That's fair, I speak quickly. Will you tell the ladies and gentlemen of the Senate whether you did or did not provide us any document in regards to Ken Paxton's Proton or Signal account?
We did not provide any documents related to a Proton or Signal account.
At one point during the questioning, I think what you had said was the Office of the Attorney General is Ken Paxton's law firm. Did I get that right?
Objection, misstates prior testimony.
It was in court today and a moment ago on the subject of Gross.
Overruled.
Thank you.
I'm analogizing, but yes, I did say that.
But of course, that kind of brings me to my next point. As a prosecutor, your job is to zealously advocate for the, your job is to seek a true and fair, I've forgotten my oath. As a defense attorney, your job is to zealously advocate. But as a civil attorney who works on behalf of the Office of the Attorney General, what is your oath? What are you supposed to do? What's the most important part of being a lawyer for the state of Texas?
Objection, Your Honor. Compound question.
Overruled.
I would say the most important part of my job as a public servant is to faithfully serve my principal and the people of Texas.
Do you believe your principal and the people of Texas to be different? Who do you think your client is, Mr. Kinghorn?
Who is my what?
Who is your client?
My client?
Yes.
Is the Attorney General.
Would you believe me if I told you that when you work for the Office of the Attorney General, you work under his authority and for him, but your client is and only ever is the state of Texas?
Objection, Your Honor. Argumentative, contains a legal conclusion.
Sustained.
Do you believe me when I say that, or do you agree with it now as you sit here?
Objection, Your Honor. Same.
Yeah, same question. Sustained.
You were asked questions about Brandon Kamek, and you relayed a conversation in which he'd called to find out about payment. Do you recall that?
I do.
And can you tell us what month and year that was?
Not with any greater specificity than what I indicated earlier.
I didn't hear you, so would you tell me again?
Sure. I believe it was after I was promoted general counsel, which would have been sometime during the month of November. But it wasn't necessarily during November. It could have been December. I don't remember exactly when it happened.
Okay. So Ryan Vassar was part of bringing you into the Office of the Attorney General, is that correct?
He was.
And Ryan Vassar was a friend of yours, correct?
Yes.
And is it fair to say that you liked and respected Ryan Vassar?
Yes.
And when he was summarily dismissed from the Office of the Attorney General, you rose to his position somewhere around November, correct?
Objection, Your Honor. Argumentative and assumes facts not in evidence before this witness. Moreover, I don't know what this line of questioning is intended to do other than improperly bolster the character of some witness who's not here. The door has not been opened to that, so that aspect of this questioning is also improper.
Overruled.
I'm sorry, could you give me the question again?
Were you promoted after Ryan Vassar was fired?
Eventually,
yes or no?
Yes.
Thank you. And it was after that that you had a conversation with Brandon Kamek, and Brandon Kamek is asking your office about payment because despite the fact that he's been employed since September, he's never been paid. Is that right?
That's right.
And as of November, there was no contract in place, right?
There was a valid contract.
Then why was he never paid?
At one time. By the time Mr. Kamek reached out, I believe the contract had been closed at that time, just trying to be specific.
So what I'm asking you is, there's a secret, private contract signed only by Ken Paxton, not kept in the office of the Attorney General at some point in this storyline, correct?
Objection, Your Honor. Argumentative, assumes facts not in evidence before this witness.
Sustained.
I don't know how else to do that. The defense's entire position is that Ken Paxton signed a contract with Brandon Kamek, correct?
Objection. This witness has been subject to the rule and doesn't necessarily, doesn't speak for the defense. It's the same question. It's argumentative. It's a sidebar. You've sustained the objection.
If I may, he was questioned at length in regards to the OAG report. Any person who's read it once or skimmed through knows that this is their position. It's not a violation of the rule. It's a question he opened.
Objection, argumentative, and lacks foundation. She hasn't laid that he knows anything about that aspect of the OAG report, and if she wants to ask that question, she can do it, but she has to lay the foundation for it and do it properly.
I'm happy to do that.
Dane, go ahead.
Did you read the Office of the Attorney General report?
I have read it, yes.
Okay, so on page 5, it reads, position taken by the Attorney General in this litigation was adverse to Nate Paul and in support of higher settlement amount to be paid by Nate Paul. Do you recall that being their position?
Objection, Your Honor. If she's reading from a document, I don't understand what it is, and I don't have it.
He's testified that he's read the Office of the Attorney General report.
I didn't understand.
He's been questioned in regards to its veracity. I intend to take him through a list of false and misleading statements to get his position and then challenge him with the testimony of the whistleblowers as allowed by the rules.
Objection overruled.
In regards to the Mitty Foundation, on page 5, it says the position taken by the Attorney General in this litigation was adverse to Nate Paul. You understand that's his being Ken Paxton's position, correct?
Objection, Your Honor. There's been no testimony about Ken Paxton's position, and there's no, are we talking about the report or are we talking about Ken Paxton? I'm still confused as to what we're doing here.
Sustained.
Is the Office of the Attorney General report in question published on the AG's website?
I'm sorry, say that again.
Is the Office of the Attorney General report published on the AG website?
Yes, it is.
And do you have to have either title status, meaning Ken Paxton, or the first assistant in order to publish it?
Yes, that's a fair statement.
And therefore, every statement put onto that website is adopted and made on behalf of Ken Paxton, correct?
I believe that the report is issued by the Office of the Attorney General. Whether that extrapolates to a legal position that Ken Paxton holds pursuant to this proceeding, I'm not going to go there.
So as an officer of the court and a government agent, you're not going to honestly say that anything published on the Office of the Attorney General website is the responsibility of Ken Paxton and something he should be held accountable for? That's your position?
Objection, Your Honor. Argumentative. She's demanding that this witness make a legal conclusion that he's justified, that he's just testified that he cannot make.
He is the general. Thank you. Is your position that he cannot be held accountable for what he posts on the website?
My position is that I can't speak to the Attorney General's legal positions.
Isn't that your entire job duty?
Objection, Your Honor.
Let him answer. Let him finish his answer.
Thank you.
No, it is not. My job is to provide advice and counsel to my client, the Attorney General of Texas.
Okay. So if you had to choose between the state of Texas interest and Attorney General's interests, whose do you choose?
I do not see them in conflict.
Okay. Then back to this point. Do you or do you not, as attorney for Ken Paxton, think that he is held accountable for the items that he posts on his website?
I don't know what you mean by held accountable. That's a very vague question.
I'll help. Are you familiar with the Texas Rules of Evidence?
Somewhat. I am general counsel, not a litigator.
Do you understand what an admission by adoption is? Or an admission because it's made by a representative? Or an admission because it's made by an employee?
I'm aware of those rules.
Do you believe that those things would apply in appropriate context to Ken Paxton?
That's not something that I've researched specific to this proceeding. I don't have an answer for you on that.
I think we're all clear on you not wanting to answer this question, so I'll move along. I'm going to give you a series of statements then, and I would like for you and I to discuss them. This investigation revealed the OAG's intervention worked to the Foundation's advantage on mediation. If I was telling you, or if that statement's about Mitty, and you have Ryan Bangert, Josh Godby, Darren McCarty, and Ray Chester all disagreeing with this statement, would even them disagreeing change your opinion as to it being valid?
Objection, Your Honor, assumes facts not in evidence before this witness as to those other folks' positions. I don't have an objection to her questioning the witness about a document that I believe is in evidence, but I think in fairness he should be provided with a copy of it.
Sustained.
So earlier when Mr. Hilton asked you if you believed in the OAG report, you're not actually saying anything in it is true or not true, or that any of us should really entertain your opinion on it, right?
Objection, argumentative, misstates testimony.
Overruled.
Can you restate the question?
Your opinion on the Office of the Attorney General report being truthful is irrelevant to this proceeding because you will not address the statements within it. Is that accurate?
I don't agree with the question as you phrased it.
Okay. Then let's talk about the foreclosure letter. You went into great detail in regards to the distinctions. You relied on 418. Is it accurate to say that applies to mayors and local subdivisions, but not Senator Hughes?
That's correct.
And so Senator Hughes's authority or name wouldn't be necessary if that was the basis of that letter, correct?
I do not believe it was necessary. That's correct.
That's a different question. If the Attorney General was relying on 418, Senator Hughes's approval would not be necessary, correct?
If I understand yes, that's correct.
In regards to 402.042, that you do need an official requester for, correct?
That's right.
And if it was an informal guidance, then no requester is needed at all, correct?
That would be my position, personally.
So in regards to items 1 and 2, you wouldn't need to involve Senator Hughes at all, let alone use his name to put forth an opinion that he certainly would never have approved of, right?
Objection, assumes facts not in evidence. Moreover, she's stating a juror's opinion without following the rules.
Sustained.
Okay, last, in regards to your credibility and the Attorney General's reliance on you, is it fair to say that you represented him in a bar grievance relying on in a government filing or a court filing? And you took the position that the Attorney General was not subject to the bar rules or the state Texas ethics rules?
Objection, Your Honor, assumes facts not in evidence.
I'm asking him, he's on the stand, it was his position.
And you're characterizing that grievance and that litigation. You're mischaracterizing it. You haven't established that any of those things are true with this witness.
That's the purpose of the questioning.
Overruled.
Did you or did you not take the position that the Attorney General of the state of Texas is not beholden to state bar ethics rules?
Objection, relevance. That doesn't have anything to do with an article of impeachment.
Overruled.
Ms. Epley, I'm not sure which, can you be more specific about what complaint you're referring to? I don't have a recollection when I sit here as to specific.
Does it feel appropriate to you that you would ever, for any reason, for any purpose, indicate that the Attorney General of the state of Texas was not beholden to bar ethics rules?
I don't think that's what we said at any point.
Pass the witness.
Mr. Kinghorn, do you know if any proton mail or signal documents that would be responsive to their subpoena exist?
I do not.
Did you conduct a diligent search for those documents on behalf of the Office of the Attorney General?
I conducted a diligent search of all documents that we had in our custody and control.
Do you have an obligation to produce documents that don't exist and that aren't in your possession, custody, or control?
I do not.
I have 1 moment, Your Honor. Pass the witness, Your Honor.
Ms. Epley, are you coming back?
No, I have no further questions for Mr. Kinghorn. Thank you.
May he be excused.
May we approach on a quick housekeeping matter? It's just the admission of some records I left at the podium, frankly.
May I excuse the witness? Yes.
That's fine with us, Your Honor.
Okay. Yes, you can approach.
And Ashley, we've been listening to testimony from Chris Hilton, one of the members of Kim Paxton's legal defense team. I do want to point out, Ashley, this is not the first time we have seen Chris Hilton publicly representing Kim Paxton. He may look familiar because he is one of a handful of employees who worked in Ken Paxton's agency and has now taken a leave. There were 6 employees who reportedly took a leave of absence from the office to work on Ken Paxton's behalf. And one of them is Chris Hilton. Chris Hilton also answered questions way back in the spring, Ashley, in hearings about the proposed settlement agreement.
And so that's interesting because if we take a step back, Chris Hilton sort of almost, directly knows as much as you would know a coworker. Austin Kinghorn, the man who he is questioning.
Yes.
He is someone who knows about this report that was filed with him, because again, he works for the Attorney General's office.
Yeah.
So he knows all about the report that was created, presumably how that report was created, what they did and did not have access to. And that raises the point, and sort of an interesting point, that Erin Epley was talking about during her cross-examination, where, she would have conversations, as is allowed, with Austin Kinghorn to request documents, to, during the discovery process leading up to this trial. And she kind of noted, through objections, but noted that every time she would ask for something, every time she would ask for documents, they would all of a sudden appear in the filings by the defense. And so that's obviously an interesting dynamic, because certainly, Tony, you and I have exchanged cell phone numbers. You would imagine most coworkers have exchanged cell phone numbers, particularly when they're doing this kind of work. And so, almost raising this question of, was Kinghorn tipping off the defense on what the prosecution wanted?
And another thing, too, that I thought was just interesting, that a practice, a tactic that we had not really seen during the direct examination of Kinghorn by Hilton, and that is, Ashley, he went through not every single article, but he went through article by article, several of them. For example, I believe it's Article 7, Article 8, aspects of the aspects that talked about things like the investigation. So, for example, asking him point blank whether or not he was directed to draft and conduct a quote-unquote sham investigation into a whistleblower's complaint. We saw Chris Hilton go through some of the very specific language in some of these articles and ask Kinghorn about them in a point-blank way. That is not a tactic that we have necessarily seen either side do.
Mm-hmm. It is something that we sort of saw Tony Busby and then Dick DeGuerin, they both have done it, where they have certainly called up an article on, the screen and then gone line by line and asked. But to have someone talk about multiple of the articles is something that, and again, it's the language. And some of that goes into the bigger question for, I think, the senators, the jurors, the jurors. The bigger question behind all of these articles was Ken Paxton's intent. Some of it was, how can you call something a baseless claim, or how can you call something a sham investigation? These are the words that are in the document,
the articles themselves,
of impeachment themselves. So if Ken Paxton did not believe himself that Nate Paul's claim was a quote unquote baseless claim, then how do you find him guilty
or that his investigation was a sham investigation?
Right. Then how do you find him guilty of,
Members,
if he believed those claims were real? So
until 1:30.
That's certainly you're hearing Lieutenant Governor Dan Patrick saying now we're about to go on a lunch break, and apparently there's going to be a little meeting.
I'm not sure we were invited to. I think we were not invited to.
Pretty sure we were not invited, and saying it to the senators. And so that is, remember, and what it may be dealing with, perhaps you will remember, Tony, that there was a motion from the prosecution yesterday to combine some of the rules.
Correct.
And to combine the rule that states currently in the rules, if Ken Paxton is convicted of one of the articles pursuant to the Constitution of the state of Texas, he is removed from office. But then senators, the jurors, will then vote on whether or not he will ever be able to run for office again. And the prosecution wants to combine those two rules to take a single vote rather than having to take a separate vote.
Which is frankly very striking in my mind. I mean, maybe I'm not getting their calculation here at all, but it seems like that really makes the vote far more consequential. It's not just a removal, but it's a banning vote. And so, it gives them only one bite of the apple, so to speak, instead of, well, we had a victory, for Democrats and Republicans who believe that Ken Paxton did something wrong. There's the victory of, well, we have removed him, but maybe we lost, for example, on the permanent removal from office, can't run for office again. But to see the House bringing forward that measure, I think is an interesting turn.
I think it's interesting, and I think it's a risky political move. Or look, here we go.
Unless there's something we don't know. Yeah.
Or is it a safe move? Is it a safe move to not have to make the senators vote individually, which granted, they're going to have to vote to combine the rules. We spent 2 days with them debating the rules. They certainly intentionally made these two rules separate.
Right.
And so,
I mean, we can imagine that the House would not be doing this, let's be honest, unless there was some advantage, to them.
To want to do this. Also to say when you convict him, or if you convict him, that he then cannot run for office again, because we could certainly live in a world where Ken Paxton is impeached on one or more of these articles, is removed from office, and a few months later, Ken Paxton is reelected to be the Attorney General of Texas.
And my understanding of that is, by the way, a statewide cannot serve the state of Texas in a statewide elected position. I think it is possible, because I'm already hearing rumors of this, he could possibly seek some sort of federal elected office. Yes, my understanding is that it would apply to a statewide, a Texas elected position.
And so certainly will be interesting to see that motion that the House put forward to combine those rules. It had to be, you have to lay a motion out in writing before the body and give 24 hours notice, and then they'll come back out and they will vote. And, we could see it withdrawn given how these
well, that's also a very good point. If they think there's no way this is going to happen, well, then forget it. We'll withdraw it.
And frankly, if the senators don't want to have to vote on, that sort of pressure.
Right.
But you also have to wonder, how inclined is a senator to say, we find you guilty, we think you should be removed from office, and even though we think you are guilty of these really bad acts, we will allow you to run for office again.
But it is life. If you draw that, if you draw a comparison to a criminal case, it's life in prison versus, the death penalty, or 50 years in prison versus life in prison. I mean,
sure. Well, and to say that, and one of the articles very much alleges that this whistleblower settlement, all of this happened to conceal the truth from voters. And so maybe the notion could be, well, now voters have had the ample opportunity to watch this themselves. And if this is still the
facts are all out there,
and if this is still the person that they want to, because it's a very heavy vote. We talk about the numbers so much, but it is a very heavy vote for the senators to have to overturn the will of 4 million voters.
Yeah, and I think just the possible combination of those two items just really, in my mind, it makes the conviction all the more difficult.
Right. And so we say the numbers, and we say, assuming the Democrats vote this way or that way, but this is really not an easy vote for any senator, regardless of political party, to convict and remove a statewide elected official from office, or acquit.
So it's 12:28 now. We will likely, we expect to hear another defense witness after lunch, but I think, as we learned yesterday, a prediction of what may happen is increasingly difficult. Difficult in this case. All we know is that we think they're coming back after lunch.
They're supposed to come back at 1:30. There'll be a short meeting in between now, their lunch break, and 1:30, but Lieutenant Governor has called them to come back at 1:30 p.m. And so we'll be back here with you at 1:30 p.m.
See you then.